Test, test.
Right. Good morning, ladies and gentlemen. It's now 10 o'clock. That was only a drill. I knew that was coming. This inquiry is now open. First of all, in the room, am I audible? Getting nods. Excellent. We are being live streamed. I have the slightly disconcerting view of myself. The live stream is working. Just to let people know, we're being live streamed throughout the inquiry. So in the unlikely event the live stream drops, we will know about it, but I will pause the inquiry at that time, because obviously if people want to listen in and there is a technical problem, I wouldn't want them to be disadvantaged. Okay, could I please ask everyone to turn off their mobile phones, pagers, etc., or set them to vibrate? And if you do need to make a call or receive a call, can you just pop outside? I'd be very grateful for that. Just before continuing, the layout of this room is slightly unusual in that I've got the public gallery up to my left. Please don't take offence if I don't turn around to look at you. I'm tending to look at the main parties around here, and I'm conscious that you're out of my line of vision. I'm not ignoring you. It's just a slightly unusual arrangement. Okay, this inquiry, as I'm sure you know, is into an appeal under Section 78 of the Planning Act 1990 by Redwood South West Limited in relation to the decision of Waverley Borough Council to refuse planning permission for what's called a hybrid application, part outline, part full. The outline application, which is all matters reserved except for access, is for up to 120 residential dwellings, access from a road linking to Midhurst Road, landscaping, emergency access, community growing space, infrastructure, including green infrastructure. The full part of the application is the erection of one dwelling with associated works, a junction alteration from Midhurst Road, associated access road to serve the development, including the diversion of a public footpath, car parking, the erection of a scout facility, nursery and an educational facility, and a suitable alternative natural green space, which I'm sure we'll end up calling a SANG throughout the inquiry. My name is Philip Ware. I am a chartered town planner. I've been appointed by the Secretary of State to hold this inquiry and decide the appeal. Now, there are a number of opening matters that I need to run through with the main parties, and then we'll have a brief look at the procedure and the programme for the inquiry. First of all, can I just identify who's appearing for the three parties? Firstly, for the appellant.
So my name is James Marici, King's Counsel, and I appear with my junior, Matthew Dale Harris, who's behind me. And we're instructed by Savills on behalf of the appellant. And so do you want me to run through my witnesses?
May as well now, yes, if you would, please.
Yes, so I'll be calling Mr. Pullen on design. I'll be calling Mr. Smith on landscape. We'll be calling Mr. Jack in relation to ecology, and we'll be calling Mr. Collins in relation to planning.
Thank you. Yeah, I've got proofs of evidence and appendices from those four and rebuttals from Messrs. Jack and Collins.
Correct, sir, yes,
okay.
Thank you.
Thank you. And for the council.
Yes, sir, good morning. I'll just have a short note of appearances passed up. My name is Tom Cosgrove, King's Counsel. I'm instructed by Lewis Jones, who's the senior planning solicitor at the council. And so as you'll see on the notice of appearances, I have two witnesses. They're not set out in the correct order. The first witness will be Robert Petro, dealing with landscape matters, and then Mr. Johnson, who sits to my left, dealing with planning matters.
Yep, thank you very much. And I've got proofs from them. And for the Hazelmere South Residents Association.
Good morning. My name's Howard Brown. I'm standing as the advocate for Rule 6. We also have two witnesses. We have Mr. Harrison on community landscape.
Yep.
And Dr. Guest on ecology.
Yep. Thank you very much. And I may as well mention it now. I know that you were originally hoping to call a third witness, but they're not available. And I've accepted their evidence as a written submission. Just double check, have the parties seen that?
This is Professor Tom Oliver.
Yeah, Professor Oliver.
When did that come in?
I think you're getting a nod from behind.
Oh, it's the evidence that was already in the proof.
It was it was
That's right,
yes,
yes,
it
we've
was
got
the,
that.
it was the evidence in the documents that
Yes,
form
we've
the
got
proof.
that, yes, thank you,
Yeah,
sir, yeah.
and that element is not being called. Okay, that's fine.
Okay,
very-
thank you.
Thank you very much. Incidentally, I gather that we can only have 2 microphones on at a time. When we get into evidence and cross-examination, I'll probably turn mine off, but it's 2 mics on at the time, I believe. Now, I have got a list of, it might not be comprehensive, but I've got a list that's been coming through to me over the last couple of days, indeed even this morning, of those who want to speak. I'll talk about the timings of that later, but I've got a fairly lengthy list. I think the easiest thing to do is I will read through my list, and if that person is here, can you just wave at me so I know you're here? And then we'll see if there's anybody else who is not on my list. I've got Clive Smith from Surrey Hills National Landscape Planning Advisor. No, who was very concerned to be heard first. Doesn't look as though he's going to be. Okay. Sorry, bear with me a sec. And then not in any particular order, and if I get the pronunciations wrong, please don't be offended. I've got a Mr. Bevis Peters or Peters. Yep, you're here, thank you. Robert Coombs. Yes, thank you. Michael Bradford. Yes. Mr. Buckler. Yes, thank you. Neil Strachan, Strawn. Apologies for the pronunciation. Danny Page. Yep. Councillor Aslam. No. Okay. Jane Devlin. Thank you. Councillor Weldon. Thank you. Maggie Hamilton. Oh, yeah, sorry, thank you. Colin McKinnon. No. I should say, incidentally, for those I'm calling out who aren't here, if they turn up a bit later on today, I'm sure we can fit them in. I just need to know who's here at the moment. A Jan Ahern. Yep, thank you. Dawn Brown. Yes. Simon Clark. Simon Clark, not at the moment. Nikki Barton. Yes, thank you. And I have this morning, and I don't know if the other parties have seen this yet, it only came to me about a quarter of an hour ago. I have seen reference to a statement from Greyswood Forest School, which somebody has asked if they could read out. Is there somebody here geared up to do that? Doesn't look like it. Right.
I think that's going to stand as a written statement because they've got their camps and stuff on this week.
Yeah, they did. I knew that they couldn't be here, but I'll have to double check this. I thought that they had asked that somebody else could read out their statement. I might have misunderstood that. Not to worry, I've got their statement. That's the important thing. Right. Is there anybody else in the room who I've not called out who's likely to want to speak? No? Okay. That's great. We'll look at the timings a little bit later on. Are the press present? Okay. I've mentioned the live stream. As far as I know, this is not being recorded, but frankly, when you're on live stream, anybody can record at any time. So that may be happening. It may not be, I don't know. I have got the letter of notification regarding the inquiry and the list of those to whom it was sent. I'll come back to the history of this particular case in a moment, but I will be taking account of the written representations that were made, the letters that came in to the council when the council were looking at it. And I will be looking again at the letters that came in when this appeal was previously heard. I'll come back to that. And obviously letters that have come in at this appeal stage for this inquiry. So I have already read all of those and I will be reading them all again. The main matters, I should explain, we had, the main parties had what's called a case management conference back in January, a virtual meeting. It talked only about the procedure for this inquiry. We didn't go into the pros and cons of the scheme at all. I mention that simply so that if anybody says, oh, well, that was discussed at the case management conference, usually abbreviated to CMC, that's what it was. It was a meeting with the three main parties to talk about the procedure. At that time, and I don't think this has changed, I put forward effectively three issues. There's a lot of overlap, but effectively three issues. The effect on the landscape, that is an issue for all three of the main parties. We're also dealing with design matters that lead into that beforehand from the appellant. So the effect on the landscape, ecology, which is an issue for the Rule 6 party and the appellant, and the question of exceptional circumstances, which is being dealt with by the appellant and the council. Just pausing there for a moment, I'm conscious I keep on saying Rule 6 party. I won't go into why it's a Rule 6 party, but there are procedure rules. The local group has applied for Rule 6 status. I'm afraid we drop into jargon. They're a main party to the appeal. They're called a Rule 6 party by everybody involved. It's also rather quicker than giving you a full title. That's where Rule 6 comes from. Conditions and a planning obligation. We will have a session on conditions and the planning obligation in some way towards the end of the inquiry. I have seen the conditions that have been almost entirely agreed by the appellant and the council. There are two conditions that are not wholly agreed, and I don't know if this email has come out, but I asked for an email to be sent out first thing this morning, basically saying that I'm content with the other conditions, but I do want a brief discussion on those two conditions that are not agreed.
I think agreement's now been reached, I think. Is that right, on all of the conditions? And I think we'll have to outline to you what's been agreed in relation to those ones that were outstanding. I think one of them at least is being deleted.
Okay.
I think.
Well, if I can perhaps have an update list sent through to the case officer, and perhaps the easiest thing to do is leave that till we get to the condition stage, and then you can explain how we've got to where we've got to. But the email, which I think is going to be coming out very shortly, basically says that subject to a couple of typos or whatever, I don't have any real queries on the conditions. I ought to have said before embarking on conditions and obligations that this is an absolutely normal part of any planning inquiry. If I were to allow the appeal, I need to know what conditions I should impose on that permission. And I also need to know what the parties who are opposed to the appeal think about those conditions, totally without prejudice to their position and without prejudice to mine as well. But it's a normal part of the exercise. It sounds as though without prejudice, the conditions are basically there and agreed. We can have a look at them at a later stage. I'm assuming there are no other changes to the conditions that I've seen. No, that's fine. At that session, which is obviously going to be very brief, we'll also talk about the question of legal agreement, just to, I think, largely to update me on the position. I don't think there's anything pending on that I'm aware of, Mr. Morici.
Well, sir, the section 106 is agreed between ourselves and the council. Obviously, there was a section 106 agreed for the previous inquiry. It's very similar. There has been one additional provision which you'll be aware of. As I understand it, the council solicitor's been away. She's back this week, and we hope to have a final version for you in the course of the week, I think is where we are.
And I'm assuming that that is by way of an update and that nothing's going to come as a great surprise to me.
But I don't believe so, no. No, I don't believe so.
Sarah, if I can assist, I think that's accurate. I think there may be some minor drafting points which are just being ironed out, but the principle is agreed. And you will need from us as well, I am conscious, and you'll get it with all due speed, a SIL compliance statement. There will obviously I wasn't at the last inquiry, but there would have been one then, but we'll look through that and update it. Well, now we've agreed it. I suspect also, it's not really my bag, but I suspect there was also 106 with the county that's either agreed or in progress, but I don't know about that, but we'll update you on that as well.
Okay. Right, thank you for that. But yeah, if you can keep me posted, if there are any documents to come through, that would be useful. But otherwise, we'll deal with those matters towards the end of the inquiry. Sorry. How is it everybody else has got water, but I haven't? Don't worry. No, don't worry. I didn't mean you to leap into action. Matter of costs, which I do need, thank you very much. I do need to raise. I'm not inviting any applications for costs for any party, but if they do need to be made, they should be made before the close of the inquiry, giving the other parties, please, as much warning as you possibly can. You'll also be aware that I've got the power to initiate an award of costs whether or not an application has been made by any of the three parties. If I were to do this, it would follow a written process with the relevant party after the appeal decision is finished. I mean, I'll say now that it is not in my mind that there is anything before this inquiry which would lead me to consider an award of costs, but obviously the three parties will make their own decisions on that later on. I do need to touch on the previous appeal decision related to this scheme. I'm sure that most, if not everybody in the room, is aware that this is the second time this appeal has been considered. I'm very conscious that certainly the main parties, and I suspect a lot of other people, were here and were carefully following the previous inquiry decision. Two things about that. As you'll know, that decision was taken to the High Court. The High Court quashed the decision. So basically the appeal itself was sent back to the Planning Inspectorate for reconsideration. I'm dealing with it from scratch. I wasn't involved in that previous inquiry. I'll come on to what documents I have read, because I have read some documents related to that previous inquiry. But can I just remind everybody that I wasn't here at that previous inquiry. I know from what I've read some of what was discussed, but please don't say, as we discussed before, because at that point I'll have to interrupt you and say, I don't know what we discussed before. So can we try and avoid, I know it's hard when you've been around once before, but these redetermination appeals, there is a temptation to assume knowledge on my part that I simply don't have. So try and avoid what was discussed before. Do it again now. It's not repetitious for me. I wasn't here. I don't know, but it may be the second point on that previous appeal decision, which I've obviously read. There may be, I don't know, legal submissions as to the materiality of that previous decision. Horrible word. But it may be that one, two, or three of the main parties will want to talk to me about how much weight I should give, if any, to what was said by the previous inspector in that quash decision. The parties are well aware of that. I'm not inviting it, but it may occur. But leaving that aside, as I say, please let's not go back over what was said before. I need to know it from scratch. Site visit, excuse me. I have seen the area generally yesterday, mid to late afternoon when I arrived in this area. I didn't go onto the site itself, it's private land, but I have got a pretty good flavour for the surrounding area, looking as one can at the site and developments in the area. So I've got a fairly good flavour of the area from yesterday. I have got from the appellant, I think it was agreed by the council, as requested, a route around the site and a list of other locations. At the end of or close to the end of the inquiry, I will go onto the site with representatives, one each please, of the three parties. I will go around the site itself. There won't be any discussion on that site visit. It's a formal visit. Perfectly okay to point out a particular tree that we've talked about or something like that, but don't give evidence about the tree. There is the tree is fine. There is the beautiful tree is not fine. It's that simple. So it's a walk around the site itself. I will also then do another walk unaccompanied around what I've already done in effect, but I'll do it again around the area more generally. Now, I know on that route plan, the appellant requested that I visit some other locations. I'm sorry, I can't remember if the council agreed this route plan. I think you did. Yeah. So the appellant has asked some other
I think the Rule 6 part, it was also sent to the Rule 6 party.
It was sent to the Rule 6 party.
Yeah.
I'm assuming, hopefully, that you're okay with the route around the site. But I know that you were concerned about the other locations. What was that I should look at? What was the issue there?
My issue was when you issue a map with a set route on it, to then say that's agreed and then add further discussion points or further points to visit, I thought was out of place.
What are these?
You sent a map out with a little blue dotted line going all around. And on the bottom, after you issued the map, it had 5 other site visits, such as the Royal School, something in Camelsdale, I think. I can't remember all the different sites. I'm just saying, why are they put on there after the event? They should have been on the map route.
Well, because those were not.
Bear with me just a
Yeah.
second. I'll get the.
I had no objection to them per se, providing they're not
Also
giving a biased view, and we just said,
Yeah, so the map is obviously the accompanied site visit route. There are some other things in the town that are going to be referred to in the evidence and which we think you should see, but they don't need to be accompanied because they are in the town. So you can see them whenever you visit yourself.
Yeah, I mean, I'm happy with that. I understand what you're saying. The important thing is that when we go on our site visit, we've got the plan for the route around the site. And I mean, I think the easiest way to resolve that is that if during the inquiry, and I'm sure it will, people refer to other locations. I mean, the appellant has referred to 6 other locations, but if anybody else refers to other locations that they think that I ought to visit, by all means, and I will. All I would say is, both in terms of that list of 6 and any others, don't just tell me to go and have a look at. Tell me why I'm going. What is the point of going to that location? But I'm happy to visit other locations as necessary. All right, bear with me a second. Right, we have got a core documents library up and running, courtesy of the council. I'm hoping, for famous last words, that there won't be any or many documents handed in at the inquiry. If there are, could they please be added to the core documents library? And please, can witnesses and advocates refer to the core documents library when you're asking questions or indeed when you're answering questions? As you can see, I work electronically. I've got a few bits and pieces of paper, but I don't have every single core. I'm not sure how many there are, but I don't have every single core document here. I will bring them up on screen. So if you're referring to a document, it should be in the core documents library. And can you refer to it in that way rather than talking about local plan review, ... Just call it CD, whatever it is, and I can find it quicker.
Sir, can I just, on that point, if I may, forgive me for interrupting. So for members of the public, there is a website which has got various documents, as you said, listed. We've got the core documents from the earlier appeal, which is, we talked about, then we've got core documents, NID, new inquiry documents, which are sort of additional ones for this appeal. Would you like things that come in now just to be added to the new inquiry document, sort of as a sort of subsection of documents handed in, whatever it is, NID 9 or 10 or whatever up to, or do you want some new number, or do you not care either way?
I think let's just run it through from the new,
where we are now.
where we are now, the new documents.
So it'd be NID, whatever the new number is.
Yeah, I
fine.
think so.
Okay, thank you.
Yeah, that would be helpful. Documentation. I will come back on this to excuse me, to the core documents. Things that I have read at least once, in most cases more than once. Obviously, the original application and all the supporting material that went with it. I've already referred to the fact that I've read all the objections that that came in at that stage and later. I have read probably 3 times now the council's report and the decision. I have read a fair amount of the history of the previous appeal decision on this appeal, and I have read the High Court judgment. Slight caveat on that, there was a big bundle that went into the High Court, and I'm not pretending that I've read all of that bundle. So if there is anything, I've read a fair amount of it, but if there is anything in that bundle that the parties think it's essential I read, please tell me. Don't assume I've read it. I'm not going to be in the least bit offended if you say, have you read X, Y, Z? If I haven't, I'll tell you. But tell me what it is I should read from that High Court bundle, and indeed why I should read it. That same point comes back in just a moment. Statements of case from the parties. Obviously, I've read the environmental statements. I have read in full once and in key parts 2 or 3 times. And then coming back to proofs of evidence, sorry, I should have said proofs of evidence, I've read a lot. Coming back to the core documents, again, same point as with the High Court bundle, don't assume I have read every single core document. I don't get enough time to do that. If there's something that the advocates or the witnesses or members of the public think I should read from the core documents, please tell me, and tell me which bit of the core document. Don't just give me a huge document, which bit of the document and why. Don't assume it. I can't stress that enough. I don't want people to go away at the end of this inquiry, whenever that may be, thinking, oh yes, the inspector has read every single document. He hasn't. It's very much down to people speaking to make sure that I have. All of that said, I have been doing this job for a long time and I pretty much know what the key documents are, but I wouldn't guarantee it. So, just turning on briefly, this is something I say at every inquiry, to witnesses and advocates, please frame, if at all possible, and it usually is, please frame your questions and certainly your answers so that they're capable of giving a yes, no answer. Absolutely qualify the answer. You will always say yes, but, no, but, whatever. But it's really helpful to me if you've been asked a question that is capable of being answered yes or no, however, please do it that way. Some witnesses in the past have a slight tendency, nobody here, but have a slight tendency to be asked a fairly straightforward question and give a very long answer, at the end of which I'm afraid I will interject and say, was that a yes or a no? So I will always make sure that you get the opportunity to answer the question and give any caveats, but please do help me by saying yes or no to begin with. Then I know where we're going. It'd be really helpful. Turning to the question of the timetable. I have set out a slightly optimistic timetable. I think I've sent 2 versions out now, starting today, running through to this Friday lunchtime, starting again next Tuesday and running through to Thursday. Hang on. Thursday lunchtime. Unless anybody says that there's a particular problem, I would start on subsequent days at 9:30. Does that cause anyone any difficulties? I think it's fairly standard now, but okay, so we're starting at 9:30 after today. Now, just running through that timetable, first of all, today, after I've finished talking, and there may be points coming from the 3 parties, but after I've finished this opening discussion, we'll hear a brief opening from the council, brief opening from the Rule 6 party, and a brief opening from the appellant. That's basically just to set the scene. We're looking at about 15 minutes each just to give them the essence of their case. Then on the programme, the rest of today, if we need it, is down for those people who've indicated that they want to speak. A number of people, when they wrote in saying they wanted to speak, referred to a time limit of 5 minutes. Not sure where that came from, not from me or the inspectorate. It might be that's the time they're given to speak at the council meetings. I don't know. But anyway, for people who are intending to speak, I'm not going to cut you off, with one exception, which I'll come to. I'm not going to cut people off at 5 minutes. There isn't a time limit that I'm going to impose. I want to hear what you have to say. So we'll hear from people who want to speak after the opening submissions. Having said I'm not going to cut you off, 2 things. One is that 5 minutes is a pretty reasonable time. So if people aim at 5 minutes, you're not going to be far adrift. The one thing I would say, though, is please, please, please don't repeat what other people have said. It is absolutely fine. I'm going to let everybody speak. I'm not going to say, no, you can't speak. But what I would say is that it's absolutely fine if you simply say, look, I've got 2 extra points to make. Apart from that, I completely agree with what so-and-so has said. Or if you don't know their names, I absolutely agree with what so-and-so has said about the landscape impact, for example. Please do that. It helps me. It doesn't diminish what you want to say, but if we keep hearing the same thing over and over again, that isn't helpful. But if you've got extra points to make, please make them. So after the openings, we'll probably take a break at that point. After the openings, we'll hear from those who've indicated that they want to speak. That is not sounding dismissive. That is all we have on the timetable for today, because obviously when I was putting the timetable together, I didn't know how many interested persons were wanting to speak. My inclination is that even if we make particularly good progress on that, I mean, we could pull the appellant's first witness forward. Getting a nod.
Yes. So Mr. Pullen's here, so I'm perfectly happy to, if you want us to do that, for us to make.
We'll see where we get to. He would, of course, be incommunicado overnight under the new rules, which I still don't understand. Okay, we'll see how that goes. So we'll hear from interested people later this morning and this afternoon, and then we might hear the first witness for the appellant a bit later on. But let's see how we go on that one. In terms of timing, I'll break at around 1 o'clock for lunch for about an hour or a bit less. I'll take a mid-morning break, just a comfort break. I'll take a mid-afternoon break, same purpose. I won't sit much beyond 5 o'clock. Frankly, after a long day at an inquiry, I find my brain goes at about 5 o'clock, and there's not much point if I carry on beyond 5. So, and anybody, people have got lives. So we will stop at about 5 o'clock. I mean, it may be if we're mid-flow and somebody says, look, 10 minutes more and we'll be done, that's fine, but broadly. For the remainder of the inquiry, I'm not going to go through it day by day. We're looking at a design element, landscape, ecology, planning. Then we will look at conditions and obligations. And then finally, we will hear closing submissions from the council, the Rule 6 party and the appellant. Just pausing on that, we'll see how the timing goes. If we can stick more or less to time or less, then we will have dealt with all of the evidence by, I mean, it's a short week, but by the end of next week. I think I've already indicated in an email to the parties that I'm musing on hearing conditions, 106 obligation and closing submissions virtually on Teams. I didn't hear any comeback on that, but it's becoming fairly standard practice now, whereas I find enormous benefit in holding an inquiry like this in person. When it comes to a discussion between a few people on conditions or listening to an advocate giving their closing submissions, I'm more than happy to do that on Teams. We'll worry about that nearer the time. We do have a third partial week lined up, but unless anybody wants to pick up on anything.
No, so the only thing I was going to say was so that I did have a discussion with Mr. Cosgrove, so I don't know how you feel about this, but I think both of us would be perfectly content in due course for closings to be in writing if that assisted, or we could do those on Teams if you preferred to hear them. So that's just a possibility going forward. So I simply raise that. And so in terms of the site visit, which you mentioned earlier, is that likely to be in the third week that we have timetabled?
Looking at the timetable for the first 2 weeks, I don't think we've got time to do the site visit in those 2 weeks. So I think the site visit is likely to be in week 3 as timetabled.
Yeah.
Quite possibly closings on Teams, conditions, obligation, closing on Teams also during that week. I don't like closings in writing. I honestly find I get much more from it if I can hear and read, but hear the advocate speaking.
So that's
so no closings in writing. I know some inspectors are absolutely fine with that. I find it more helpful to hear them read. There was one matter that I wanted to pick up on, and that was just before I opened the inquiry and we heard the fire alarm. I was just saying hello to Mr. Brown for the Rule 6 party. You mentioned, Mr. Brown, that there was an error in the timetabling, in that there wasn't a slot in the timetable for the Rule 6 party to cross-examine the appellant's landscape witness. Was that your point?
That's correct. On the Thursday, the 10th, after the appellant was Smith 2.5 hours, we didn't put any questions. It's an admin error on our part, not the timetable.
Okay, yeah, but I was going to say that when you very helpfully indicated how much time you'd want on various elements, you didn't mention cross-examination of that.
No, I missed that, sorry.
No, don't worry, these things happen. I assumed it was an error on my part, they normally are.
Oh no, it's always me.
No. How long do you anticipate that might take?
Maximum, and that 1 hour. I wouldn't think any more.
Okay. We will, I mean, we'll fit that in somehow.
Thank you.
At that point, whether that be Thursday afternoon, Friday morning, we will fit that in. The only thing I would say is that I do need to be away lunchtime on Friday. I can't spin it into the afternoon. I have the misfortune to live in North Yorkshire. It'll take me hours to get back. But we will absolutely get you in on that, because obviously you're giving landscape evidence from your side. Quite reasonable that you should want to cross-examine. I didn't spot that omission. There we are. Once we have closed the inquiry, be that on Teams or in person. Only very exceptionally will material be accepted once we've closed. Very exceptional. The last couple of inquiries I've done, various parties have wanted to put in documents after the inquiry has closed. With one exception, I've turned them all away. The only thing that, this is an example, but the only thing that I would be inclined to accept after the inquiry closed is, for example, if there is another change in national policy, or if there is an appeal decision directly related to this scheme that is issued, or indeed if there is a council decision directly related to this scheme. I find it hard to think in general terms as to what else might exceptionally be accepted. Sorry. So the general rule, once we've closed in a couple of weeks' time, no more material. And if anybody does try and put material in, don't be surprised if it gets sent back. Right. I have said that all I need to. Are there any housekeeping matters that we need to pick up on? Anything?
Just a practical reason, I think each evening this room is being used pretty much for other things. So in the electronic world, it's less difficult than it was in the past, but we do have to remove stuff in the evenings.
Okay, thank you. So everything out in the evening. Anything from, excuse me, anything from Mr. Brown?
So I think there is someone in the public gallery, but so can I just, there's a couple of things, sir. One is when third parties are speaking later on today, if any of them have printed copies of their speeches, it might be a good idea if they could ask the council whether they're able to copy them so that you and others in the room could have a copy of what they're reading out. So that's just my suggestion, because it'll make it easier for everybody in terms of note taking, if that's possible.
Just pausing on that would be really useful. I should have mentioned it. Absolutely fine if you don't have any notes or if they're just bullet points. But if people are reading from a statement, could the council please copy that? That would be helpful. It'll save my typing.
We'll certainly do that. So there might be a little delay. We won't always have, Mr. Johnson and I will always be here, but we can send a message and get someone to do that. It may not just be immediately done within 2 or 3 minutes.
No, well, what we'll do after we've picked up on any other points, we'll hear the opening submissions, then we'll pause for quarter hour, 20 minutes. If anybody who's going to speak today does have notes that they could let the council have, that would be really useful during that break. Good point.
And so the only other thing is when we get to Mr. Pullen, which may be today or maybe tomorrow, he's doing a PowerPoint presentation, which I've given in hard copy to my learned friend already. It's almost all stuff from the evidence already, apart from 2 Google Earth maps, which I've shown to my learned friend. We've got them hard copy. We can also present them on a computer so that those following online could see it, but really it's just to show the visual images to speak to that are in the evidence. I can give copies out of that later or now, it's up to you. So I've got hard copies and we can do it electronically as well. I haven't checked the technology side about how we would present, but presumably we can present through Teams, do a PowerPoint through Teams, I don't know.
On Teams.
Oh, we're not on Teams. What are we on? We're just like Zoom. I think you can do it through Zoom. We'll have a look at that.
We'll have a look at that. But I mean, thanks for the update. I'm absolutely fine with that. And hard copy at lunchtime, if that's suitable. And obviously also at lunchtime, we can have a look at the technology, see how that would work for either later this afternoon or tomorrow morning. Absolutely fine. And so the only new information there are a couple of
there's a couple of Google Earth images which I've identified to my learned friend, and I've explained to him why they're in there. I haven't shown them yet to the Royal Six Party, so we can give them a copy.
Again, please, over lunch, just so that you know what's coming. So it's all existing material reshaped into the presentation, with the exception of a couple of Google Maps. Okay.
Can I just ask a quick point? I notice a lot of people seem to be sitting on the floor in the public gallery or on the stairs rather than on chairs. I just wonder if they can come down onto the arena.
Yeah, I'm sorry, I hadn't noticed that. My apologies. You're slightly around the corner from me. I mean, there's a whole row of seats behind the council here. Yeah, do please come forward. Sorry, I wasn't intending to torture you by getting you to sit on the floor. I mean, if you're happy to do so, fine. Yeah, thanks for that. I hadn't spotted that. I could just see heads. Mr. Marucci, I think you had another point.
No, sir, that's everything.
Well,
Thank you.
that's it. Okay. Right. Right, bear with me just a second. Okay, in that case, my suggestion for the openings would be the appellant first, then the Rule 6 party, and then the council, and then we will take a break, 1 or 2 bits of documentation. Mr. Marucci.
Thank you, sir. I'll get the copies to be distributed of the opening speech.
Thank you. These will go in as core documents, by the way.
Yes, we'll put those into the inquiry documents. Thank you, sir.
Okay.
So by way of introduction, the appellant seeks planning permission for an appeal scheme comprising up to 110 new dwellings in outline, along with full permission for 1 dwelling, access, a scout hut and forest school, and the landscaping needed to create a large area of strategic SANG. 35% of the housing, 39 units, is to be affordable. That is above the policy requirement. Moreover, the appellant has also offered a financial contribution towards off-site affordable housing in Hazelmere and Hindhead. The proposed SANG, following approval of reserve matters, is to be large enough to mitigate recreational impacts on the SPA for development across Hazelmere and beyond, including long-stalled allocated sites. At the opening of the first inquiry in early 2024, we began by emphasising the acute need for market and affordable housing in the borough and the intractable nature of the problem at Hazelmere in particular. We said that without sites like this one, a high-quality, carefully designed landscape-led scheme on the edge of one of the largest and most sustainable settlements in the borough, the imperative to take up opportunities for sustainable development is only going to increase. The intervening 14 months have rather made our point. First, the housing land supply position has deteriorated very significantly. Whereas the council originally contended for 4.1 years of housing land supply, a shortfall of 629 dwellings over the 5-year period, the agreed position is now only 1.28 years, a shortfall of 5,777 homes across the period 2024 to 2029. This is not just a result of substantial increase in the housing demand now identified by the revised standard method for the borough. It also stems from a continuing and persistent failure by the council to take meaningful steps to address the problem in either the short, medium or long term. In the short term, the council has failed to enable the progression of consents for the sites which have already allocated under the local plan, effectively reaping the rewards of the problems inherent in the strategic choices it made in the local plan part 1 and local plan part 2. At the borough level, the council has finally come to accept that its major strategic allocation, Dunsfold Park, is not deliverable. At the local level, Hazelmere has seen an almost total stagnation of its LP2 sites, partly because of individual problems with those sites, but also because the council has failed to identify a proper form of strategic mitigation for recreational pressure on the SPA. The numbers tell the story. So not only is the 5-year housing land supply shortfall massive, 577 dwellings, if one considers the period to the end of 2032, the local plan 1 period, the evidence shows a potential shortfall of 8,026 dwellings. While HDT results have been good, the number of deliverable outstanding planning permissions has fallen substantially for large sites from 2,008 dwellings to 1,115. The council seek to point to the HDT, that's housing delivery test results, to suggest the picture is not as negative as all of that. But the delivery test is, of course, backward looking over the past 3-year period. And we know the period from 29 to 2023 was affected by COVID, and consequently adjustments were made by the government to the calculation during that time. More importantly, the test is not representative of the current housing need, which has changed dramatically with the new standard method calculation. Looking forward over the next 5 years, it's clear and agreed that the shortfall is massive. The housing delivery test performance figures for the past are therefore of little or no relevance now. In the medium or longer term, the Council showed little urgency in bringing forward a new local plan. The December 2023 Local Development Scheme set out a programme to adoption in November 2027, but the March 2025 LDS has already moved that back to July 2028, while significantly shortening the time budgeted for examination, yet it's still projected to take longer than the government's target of 30 months. Despite a call for sites in Q1 of 2024, no land availability assessment has been published, and it's uncertain whether one is currently even in draft. Adding to this, the uncertainties created by local government reorganisation, it seems clear there will be no new local plan in Waverley for many years to come. The Leader of the Council wrote to the Secretary of State on the 19th of September 2024, and we understand this is still the Council's official position in relation to the implications of the revised standard method. The letter states that the standard method therefore does not provide a credible basis for preparing our new local plan, and it states that the level of growth required to meet the standard method assessment of need is simply unachievable in a borough like Waverley. At this time, without an LAA, the Land Availability Assessment, or draft options emerging local plan, it is simply impossible to know this. This does, however, indicate the scale of the challenge and the requirement for the Council to plan positively now, including decision-making, to turn around the very poor housing land supply position. This makes it all more and more important to look at sites on their merits and in their contexts. And in this context, the appeal scheme presents what we say is an exceptional opportunity to deliver high-quality, sustainable market and affordable housing on the urban edge of one of the borough's 4 main settlements, while at the same time unlocking development in and around Hazelmere. The site sits on the southern edge of Hazelmere, adjacent to the Phase 1 site consented by Inspector Huckenhull in February 22. It lies within the Surrey Hills National Landscape. But this is not unusual at Hazelmere, where the LLPP2 has already seen a necessity to allocate no less than 3 sites in the national landscape. The appeal scheme is agreed to be major development, and as such, the appellant must show exceptional circumstances. But if it does, then it's anticipated it will be common ground that the tilted balance would then apply and permission should be granted. That must be right. The exceptional circumstances test entails consideration of all material planning factors. It follows that all the arguments in this case go to the question of whether exceptional circumstances exist and whether the development is in the public interest. In approaching this question, paragraph 190 requires decision makers to consider 3 particular things: A, need and economic considerations, B, cost of and scope for developing outside of the designated area or meeting the need in some other way, and C, any detrimental effect on the environment, landscape, recreational opportunities, and the extent to which they could be moderated. These criteria will be picked up in the evidence and under your main issue, sir. At the outset, we make the following points in relation to the approach. First, the test in paragraph 190 may be a high one, but it exists in order to reflect the need for major development to be able to come forward where needs are not otherwise being met. The test is the same whether or not a site is allocated, and it is in fact lower than the very special circumstances test required for inappropriate development in the Greenbelt. Thus, Inspector Jones noted at paragraph 798 of the Turndon appeal, while it may be preferable for any new development sites to come forward initially via the plan-led process, paragraph 177, which sir is now 190, provides a mechanism by which major development can be delivered in AONBs via the development management process, regardless of whether the site in question is allocated in the plan or not, but only if that high test is met. Second, in considering whether there are exceptional circumstances, all the benefits of the development in question can be taken into account. It is not necessary to show that any individual benefit is itself exceptional, nor that they would be unlikely to occur in a similar fashion elsewhere. Third, although the legal duty securing the protection of national landscapes has now been changed to require public authorities generally to seek to further the purposes of the national landscape, rather than merely to have regard to the purposes in the exercise of its function, this is primarily a duty of process rather than outcome. And as the High Court has recently confirmed in the New Forest National Park case in relation to the equivalent duty in relation to national parks, which also apply here given the adjacent South Downs National Park. The duty requires a planning authority to determine whether the proposed development is in conflict with the statutory purposes or would undermine their fulfilment, but it is not a duty necessarily to fulfil those purposes. A planning authority must determine whether the proposal is in conflict and consider whether any compensatory or mitigatory measures are available which might reduce or avoid that conflict. However, ultimately, it will have to reach a judgment about whether to grant permission, and in doing so will have to have regard to national and local policy by virtue of Section 70 sub 2 of the 1990 Act and Section 38(6) of the 2004 Act. As such, it's doubtful whether the statutory duty actually changes the balance of considerations. The statutory purpose of the national landscape and the impacts remain the same. The exceptional circumstances test already recognises the need to take account of any adverse effect on environmental and recreational value and for it to be moderated as far as possible. We turn now to deal with the main matters that you identified at the CMC. But first, we pause to restate our position on the legal risks attendant to any reliance by USO on the conclusions of the judgments of Inspector Bristow. One, the decision of Inspector Bristow was quashed by the High Court. The quashing was by consent, with the Secretary of State conceding the decision was tainted by procedural unfairness as a result of PINS failing to copy the appellant into material correspondence. This has left the other grounds of challenge undetermined. Once the Secretary of State accepted the decision would be quashed, they became academic. Secondly, the other grounds of claim were fundamental to the decision, included one, an allegation of apparent bias in the way in which the inspector had reached his decision as a whole, and two, specific attacks on his conclusions on matters such as the benefits generated by the SANG and of biodiversity net gain. Thirdly, we acknowledge that authority suggests that in some circumstances, the reasoning of a decision maker may remain legally material if the decision is quashed for reasons which do not affect the conclusions. Fourth, however, here the point is that no part of the previous decision can safely be relied on. The whole decision is tainted both by procedural unlawfulness, for which the decision was quashed, but also by the undetermined allegation of apparent bias. Any future decision which relied on it would risk being tainted in turn. For these reasons, we ask you, sir, to disregard the previous findings of Inspector Bristow. While the appellant's witnesses have sought to engage with those findings out of caution, and so given that you had not indicated whether you were minded at this stage to view the previous decision as material or not, this should only be had regard to insofar as it seeks to explain why the professional witnesses have reached the overall conclusions they have. So even if you, sir, contrary to our case, were to consider that you should have some regard to Inspector Bristow's decision, you will need to bear in mind the many changes in circumstance since that decision, including one, the Labour government, which came to power in July 2024, has made it very clear that significant increases in supply of housing are required, for example, through various ministerial statements and correspondence, with the government now aspiring to 1.5 million new homes by 2029. Secondly, a new NPPF. Thirdly, the new standard method. Fourth, the considerable deterioration in the Council's 5-year land supply position. Fifth, the approval by the Secretary of State of the highly relevant and comparable Turndon appeal. Sixth, the removal of 2 trees by Surrey County Council at the access to the appeal site. Seventh, the further vegetation growth and the new AVRs. Eighth, the undertaking of a detailed design review, contributing to a more detailed design code condition. Ninth, the publication of guidance on the new statutory duty in respect of national landscapes. And 10th, Natural England have reconfirmed their agreement both that the SANG is capable of meeting wider needs for mitigation of recreational effects, and that it's the only proposal that has been approved by Natural England in Hazelmere area to meet future development needs. And then finally, 11th, the offer of additional affordable housing contribution. So we turn to market and affordable housing need. It's been a central part of government policy since the publication of the NPPF in 2012 that sustainable development requires the housing and specialist needs should be met where they arise. The policy imperatives have been redoubled under the current government, as reflected in the various ministerial statements and correspondence that you have. The Council have struggled to meet these needs for many years and at the present time show no sign of even approaching the scale of the challenge. As already mentioned, a new plan is many years away, and it's inevitable that speculative and windfall schemes, including in protected areas, will have to come forward and be consented if the currently dire 5-year shortfall of 5,777 homes is not to get even worse in the coming years. The size of the shortfall permission is only matched by the scale of the need for affordable housing shown in the data produced by Tetlow King. On their apparently unchallenged figures, there's now a need for 770 affordable homes per annum across the period 2020 to 21 to 2033 to 32. about 50% of the overall housing need figure set by the standard method. In Hazelmere, the figure is 118 affordable homes per year. This is not an abstract or technical matter. As Mr. Collins identifies, there are dramatic consequences for affordability in the borough, even beyond the supply of affordable housing products. Waverley's median house price to median wage stands at 17.11 higher than Guildford's and England's, with the borough forming one of the least affordable parts of the South East. It's thus self-evident the plan has failed to meet Waverley's needs. The situation can only be rectified by a full local plan review being completed, not likely to happen soon, or permitting housing on sites which are not allocated or envisaged for it in the adopted local plan. Now, measured against this, the appeal scheme will contribute to meeting the housing need in two significant and distinct ways. First, it will provide 111 dwellings, 35% of which will be affordable in excess of policy, and there is, of course, the additional offer for further off-site contribution. Mr. Collins contends that each of market and affordable housing deserve the highest category of positive weight, substantial, while Mr. Johnson views them as benefits of significant rather than substantial weight. Secondly, the appeal scheme will secure a large, high-quality SANG. The final scheme will be 12 hectares and mitigate the impact of 464 dwellings and be able to do so over a larger distance, up to 4 kilometres from the site. This will enable the site to mitigate all of Hazelmere's LPP2 allocations, not just the town centre sites, including the Royal School and Old Grove, as the plan below shows, taken from Mr. Kite's annex. These allocations are effectively undeliverable at present, and as Mr. Collins will explain, there's no real prospect of any other mitigation solution being found in the next few years. It's worth noting the SANG here is of exceptional quality. Many candidate SANG sites require significant remodelling, planting to provide the kinds of varied and interesting environments which Natural England seeks. By contrast, the proposed SANG here is, as you will see on your visit, oven ready. It meets all of Natural England specifications, where many only come close, and will offer a highly attractive alternative to the SPA for dog walkers and the public more widely. At the first inquiry, the council's planning witness called it an ideal or perfect SANG. Moreover, the appellant has offered to make the SANG available to allocated sites at exceptionally low cost, being pegged to the Farnham Park SANG rates operated by the council. As Mr. Collins explains, these rates are significantly lower than comparable SANGs in nearby Hart and Rushmore councils. Both Mr. Johnson and Mr. Collins recognise that the SANG would be a benefit of equivalent weight to the direct contributions made by the appeal scheme to each of market and affordable housing. I turn to the effect on the landscape character of the national landscape, the national park. The appeal scheme has been carefully scoped and designed, founding its choices on a thorough understanding of the intrinsic landscape character and scenic beauty of the national landscape more widely and in the specific context of the site. As Mr. Smith and Mr. Pullen explained, the proposals respond to the context and character in a number of highly positive ways. The new houses will be placed into a small part of the site within paddocks lying immediately adjacent to the main settlement to the north. The homes will be of very high quality, reflective of the settled elements of the national landscape and recognising its intrinsic character and beauty. The access will be provided in a characteristic way through the use of a lodge house and associated positive landscape interventions, all of which will contribute to the creation of a new design landscape capable of becoming cherished in precisely the terms envisaged by the Surrey Hills Environmental Design Guide. By pulling the homes into the smallest proportion of the site, some 22%, the design allows the scheme to secure the balance for beneficial management through a LEMP and SCMP, while encouraging access to it and the national park beyond by bringing in public access and introducing new younger users through the Scout Hut and the Forest School. The resultant overall impacts in landscape and visual terms are discussed by Mr. Smith and Mr. Petro for the council. They agree that views out of the site are largely screened due to a combination of topography and high tree cover, that there are no negative effects on the national park or its setting, and that the adverse effects post-mitigation are limited to the two landscape character areas adjacent to the settlement edge and Midhurst Road, LCA 1 and 2. Beyond this, there is relatively little in common, with the two witnesses reaching significantly different conclusions about the overall effects. So the appellant will ask you, sir, to prefer the evidence of Mr. Smith in each regard. Mr. Petro's evidence, we say, is inconsistent and pays insufficient attention to the detail of the site and the scheme itself, which leads him to overstate the adverse visual effects. He does not properly recognise the differences between the two LCAs, which are to be built on, and those further to the south. And he does not properly take into account the character of the national landscape, and in particular the information provided by the management plan, as now encouraged by DEFRA's guidance on compliance with the new Section 85 duty or the SHEDG. The appellant's evidence will also show that there's no real other option for meeting Waverley's needs other than development in equally or more sensitive locations. In accordance with NPPF 190B, Mr. Smith's evidence sets out an analysis of the agreed list of possible alternative sites, concluding there are few sites within the borough which would be preferable in landscape and visual terms, and none adjoining the urban edge of Hazelmere that can make any meaningful contribution. Ecology. The potential effect of the scheme on bats, dormice and reptiles in terms of survey information and adequacy of mitigation strategies was raised by the council through reason for refusal 2, alongside impact on wildlife corridors. By the last inquiry, both issues had been resolved through submission of further information considered in detail by the Surrey Wildlife Trust. The Royal Six Party now seeks through a composite proof of evidence, only some of which will be spoken to by Dr. Guest, to revive all of these issues alongside a concern about the BNG assessments, itself an attempt to revive an argument raised on the neighbouring Phase 1 scheme, but rejected by Inspector Hockenhall. Mr. Jack, a suitably qualified professional ecologist, has rebutted all of these points in his written evidence, and the consequence and correctness of the points made in relation to wildlife corridors will be explored by Dr. Guest. There are no unacceptable impacts which arise as a result of the scheme. In fact, as the council agree, the scheme is capable of giving rise to benefits in terms of biodiversity net gain, to which Mr. Johnson gives moderate weight, i.e. just one rung lower than the weight he gives to the combined contribution of affordable and market housing. This is despite the absence of a statutory or policy requirement for a particular level of net gain. Other benefits. Beyond mere acceptability, the appeal scheme also offers a range of other benefits which contribute to the exceptional circumstances case. The new Scout facility and Forest School will each deliver real social and environmental benefits. Paul Buckler, chair of the Hazelmere Scouts, will attend and speak to the pressing need for the new facility and the benefits which it will deliver. Richard Dean of Grayswood Nursery School, the proposed operator of the Forest School, is unable to attend due to the Easter holidays, but has put in a further written statement which the inspector is asked to take into account. The Scout facility will provide a high-quality replacement for their existing, rather dilapidated facilities at the youth campus site in Weyhill, in a context where no other suitable local alternative is available, and will also assist in enabling the release of that site for housing. As Mr. Buckler explains in his February 25 letter, the scheme presents a transformative opportunity to secure a permanent home. That permanence is particularly important because, as he explains, the Scouts have faced considerable uncertainty in terms of their ability to stay on their current site. At the last inquiry, the council vociferously denied that the Scouts might be left without a home and insisted that the grant of a new lease to them was imminent. But it's revealing that over a year later, 15 months later, the issue appears not to have progressed one jot. The Forest School will also meet specific needs for which no other long-term alternative site is known. There are also local economic benefits, a matter that's specifically referenced in paragraph, that should be 190, Sir A, of the NPPF. An economic benefit statement was included with the original planning application, appended to the paragraph 17 STEM statement. A version updated to the first inquiry was appended to Mr. Collins' proof. The economic benefits of the scheme are summarised in section 14, and it's evident they were accepted by the officer's report and that due weight should be provided to the contribution in respect of 30 on and off-site net permanent jobs, 1.7 million per annum gross value added, increasing local residential expenditure alongside about 4.8 million in SIL receipts and a range of other increased taxation benefits. Further, the appeal scheme will enhance public access to the countryside, including the national park, leading to a scheme which fulfils, we say, the purposes of the national park overall and the national landscape, deliver net gain above policy, restore and enhance wildlife corridors. All of these benefits, as discussed in the evidence of Mr. Collins, add to the exceptional circumstances case. In all other respects, it is common ground the scheme is acceptable. Indeed, the appellant would say more than acceptable. The appeal scheme is well designed. Acceptable densities and layouts can be achieved. There will be no heritage harm. It provides suitable highways mitigation. It raises no air quality, pollution or draining or flooding concerns, and it will meet the required modern standards for energy efficiency and sustainability, representing a considerable improvement on the existing housing stock. So by way of conclusion, for all these reasons, the appellant considers the test for exceptional circumstances is met, and clearly so. The appeal scheme offers a truly exceptional opportunity to unlock much needed housing at Hazelmere on a site which will not only have limited landscape impacts, slight adverse in Mr. Smith's assessment, but will also enable a significant increase in access to the national landscape and countryside itself. The appellant will in due course invite you to allow the appeal and grant permission. Thank you, sir.
Thank you very much, Mr. Ricci. Sorry, could we stay quiet in the public gallery, please? Hello? Could we stay quiet in the public gallery, please? I lost the last couple of sentences there because I was distracted. If you do need to have a conversation, could you please go outside? It really is important that I listen to everything that's been said. Thank you. Thank you, Mr. Ricci. Sorry to get your name wrong.
Thank you, sir.
Mr. Brown, over to you.
Thank you. I do have a hard copy here, one off, which is a bit difficult.
Right, that's fine. If you, yeah. Again, when we broke, I wonder if you could give that to the council. I won't make any notes as we go through. If you do depart from the script, let me know and I'll make a separate note of it.
Okay,
But otherwise, floor is yours.
thank you very much. Yeah, thank you. Good morning. My name is Howard Brown and I represent the Rule 6 party as its advocate. I'm a layperson and not a lawyer. I should also point out that I have never been an advocate at a planning inquiry before. We, as the Rule 6 party, support the general position of Waverley Borough Council as the local planning authority with respect to the appellant's planning application. That is to say, we object to the proposed development. It is also the case that we support the reasoning for the previous inspector who concluded that the proposed development's harm to the national landscape was not outweighed by its purported benefits. Having said that, we seek to assist in this inquiry by providing some balance in the cases being made, by presenting the community's perspective on the demonstrable, irreversible and negative impact of this development on their own town and its surrounding landscapes. We bring invaluable local knowledge, first-hand, on-the-ground evidence, showing how deeply the community values this countryside designated as national landscape, and how the purported public benefits presented by the appellant do not even remotely outweigh the damage to that countryside. We are here because we care. We care about the local ecology, the landscape, and the people who live and work in Haslemere. Our representation. As a self-represented group, without formal legal counsel, I serve as the advocate of the Rule 6 party, being chair of one of the constituent member organisations. I'm very familiar with the landscape concerned, and I'm a local resident and live off Scotland's Lane, although I am not adjacent to the area of the proposed housing itself. The Rule 6 members are 4 organisations: Haslemere Town Council, which comprises of the elected parish councillors representing approximately 17,300 residents. Amongst its purposes, the Town Council provides input to planning and development matters, as well as furthering the public interest for the benefit of the town and its residents. Haslemere Vision, in particular its biodiversity group, has no formal membership. It is a local organisation comprising of local residents together with representation from various local stakeholder groups, including the Town Council. It was originally constituted to consult and develop Haslemere's neighbourhood plan. It is a not-for-profit company limited by guarantee. Since the adoption of the neighbourhood plan, the group has mainly focused on active travel and biodiversity initiatives. HSRA, Haslemere South Residents Association, has 219 local resident members, and that has gone up since the first submission of the statement of the case. It is an unincorporated association, and it has particular focus on the protection of Haslemere's green spaces, notably in the south of the town, as well as other matters of interest to local residents. The Haslemere Society has 415 members. It's a local civic society, the registered charity, and a member of the Civic Trust. It was established in 1884, that's 141 years ago, by Sir Robert Hunter, one of the 3 co-founders of the National Trust, to organise concerted action for the improvement, protection and preservation of the rural scenery, features of a local interest in the towns and villages within the Haslemere area. Give me a sec. These organisations comprise of different membership groups. In fact, there are only 33 names overlapping the two groups for the membership, demonstrating a distinct demographic and representation across the different areas. Haslemere is a community with deep cross-cutting networks, ensuring genuine representation in this inquiry. The Rule 6 Group is a true community voice, reacting to local concerns with sincerity and transparency. So we turn to community opposition and the historical content. The public opposition for this proposal is undeniable. There were 505 written objections, in addition to the 244 objections from the first appeal. The previous appeals administration error should not negate the weight of the objection points raised by the first inspector, the statutory bodies, or the general public, particularly those emphasising landscape damage. The anonymised data confirms the majority of Rule 6 individual group members have submitted written objections to the development. This is a clear and sustained community objection. The depth of the community concern is reflected in the objections and today's public gallery. The original 240 virtual attendees in January 2024 are also a key consideration. It is not just an issue of planning policy, it's about real people, real landscapes and real damage. Objections include those from two members of Parliament, Mr A Griffith, who I believe is Linchmere, and local MP Gregory Stafford. And also statutory bodies, Surrey Hills National Landscape and Natural England, who raised primary objections. Despite the appellant's claims, Natural England's position does not support this development, which is in NE3 December 2024. Landscape. The Rule 6 party asserts there are no exceptional circumstances as required under the NPPF Clause 190, and that granting permission to the appellant's application would not be in the public interest. In contrast, the impact of the proposed major development would be demonstrable, permanent, and cause significant harm to the national landscape. It will also have a significant impact on the site's biodiversity. Haslemere has a current and valid neighbourhood plan, which is applicable to local development up to 2032. The proposed major development is contrary to the policies in the plan and lies wholly outside the town's designated settlement boundary, as defined in the neighbourhood plan and the LPA's local plan LPP2. Although the Rule 6 party will not be providing a professional landscape expert, we defer that largely to the LPA submission and evidence in this context. We shall be providing evidence of the local value of the landscape to the community. This is very important given the question of the loss of amenity to the community of that current provided by the high quality of protected landscape on which the development will be built. Mr. Chris Harrison will be the Rule 6 party witness to the community value of the landscape. This will comprise of evidence as to the amenity value of the public, including the townspeople of Haslemere and the surrounding villages and the national landscape. Sir, you're invited to give significant weight to this evidence, albeit that is qualitative in nature. Its importance is in the balancing of what is in the public interest in your decision. One point I'd like to make is on the outset of this respect to the private ownership of the site. The appellant states in the core document CD 2.7, and quote, in terms of the landscape, the application site is currently in private use and offers no existing benefits, end quote. The fact that this site is in private use does not mean that there are no existing benefits. The countryside's benefits are not limited to those who stand in a specific place, whether a pasture, wood or a forest. Rather, the benefits are those who stand in place and to those who view the place from the outside. In the case of the proposed development site, it is precisely the benefits of the countryside as part of Haslemere's special landscape character that will be impacted, as enjoyed by the community, as its members drive, walk, run, cycle, or quietly sit in the surroundings itself. Furthermore, the protected designation of land as a national landscape does not depend on whether it's privately owned and used as not. Very little has changed since the first appeal, except for the strengthening of the land protection under the NPPF. The site now holds the highest level of government and planning protection to prevent urban sprawl. Development should remain within the settlement boundary and near transport hubs, not on protected landscapes. We support the right homes in the right places. This is neither. Since the initial objections, the landscape has undergone two significant changes. Following the submission of Rule 6 Ecology Statement, all the non-Indigenous screening vegetation on the north boundary was removed, exposing the site and disrupting its tranquility. Sadly, the pen, which is a 2-metre deer fence trap, remains on the site. As mentioned previously, key trees along the Midhurst Road, protected by tree preservation, were felled immediately before this appeal and before any determination. The TPO did state that the tree removal would cause significant harm to the amenity view. As regards to the biodiversity, the Rule 6 party argues that the figures asserted by the appellant with respect to the biodiversity net gain arising from the proposed development may not be dependable. Reference is made to the conclusions of the expert Professor Tom Oliver submitted in his papers. As mentioned, it is regret that inspectors are aware that Professor Oliver is unable to attend this inquiry for reasons shared with the inspector. However, Professor Oliver is prepared to provide further written information should the inspector request it, in particular if he needs a result of the exchanges that take place during the course of this inquiry. Nevertheless, the Rule 6 party shall provide evidence through the participation of Dr. Guest, who, although not a professional expert in biodiversity, has relevant expertise and experience in the field of ecology. Key concerns for the public. In the interest of assisting the inspector, I'd like to take the opportunity briefly to draw your attention to other areas of concern raised by local residents and members of the public beyond the environmental harm of this proposed development. The public has raised key concerns about road safety risks, junction flooding, road safety including the speed measurements which were documented in the first appeal. The water supply issue, local potable water shortages already require bales of deliveries, showing there's a infrastructure and it's inadequate, can't say it, and it's how it's inadequate. Shouldn't put that word in there. I would like to say we have deleted the next part because we saw on the notes that the housing number kept changing. It goes from 110 to 111 to 114 to 130 throughout the documents. I'm sure they're just typos and changes, but some of our evidence on the water was about the number changing and whether Thames Water had provided additional numbers because they blocked the housing number to 40 new dwellings in Hazelmere because there wasn't an infrastructure supply. But because the housing numbers keep changing, we're not sure if this is now correct. And we asked that that ought to be brought to attention and Thames Water ought to be contacted. We did try, but we got no response from them in time for this appeal. Second one, affordability. Homes in this development would require local key workers on an average income to gain a 90% mortgage, which would be approximately 19 times salary, far beyond the reach of all and from most building societies. This is based on payscale.com and Olivia Homes current pricing. I then turn to the footpath 597. The proposed relocation of the footpath is a further issue raised by many residents. Moving a historic footpath, now going to be between two roads, severs its natural connection with the national landscape and reduces its tranquility. Upgrading it to a bridleway is poorly thought out, as it will simply direct riders and horses straight into 40-mile-an-hour traffic. We'd invite you, sir, to review this aspect as opposed specifically during your site visit. Additionally, the southern end of the footpath has a small car park at the proposed junction, but it seems to lack the capacity needed for all the expected visitors. Balancing the public interest. A starting point for evaluating the public interest is to ask what the public want and who is mostly directly affected. A survey of Hazelmere's public in 2016, conducted as part of the town's neighbourhood plan consultation, showed that over 90% did not want major housing developments on greenfield land outside the settlement boundary. And even lower income families who needed affordable housing were not in favour, as they needed housing nearer the town centre, schools and shops. As an aside, I'd note that the statutory protection afforded to the national landscape is equivalent to that protection given to the national parks, and in the public interest in preserving them from large-scale housing developments is reflected in the statements for the current Prime Minister and the Secretary of State for Housing. They advocate building on brownfield sites and so-called greyfield sites, but not on national parks or, by implication, national landscapes, because the preservation of that protected countryside is a dominant public interest. Excuse me a second. The appellant emphasised that 78% of his land is being offered to the community as green space. But it's already green. Surely the relevant percentage is to focus on is that the site is today 100% natural landscape green space. In other words, the appellant's case in that eradicating 22% of the beautiful countryside at Scotland Park is made up for by the fact that 78% is not being eradicated and it has a few plantations. How is that in the public interest? Subsequent to the consultation mentioned above, Hazelmere's public supported local plan development site allocations did not allocate Scotland's Park site. The fact that the appellant points to a nearby village in Chiddingfold as having associated national landscape land at Queensmead for development is neither here nor there. If the Chiddingfold community saw that public interest for them, fine. Hazelmere has evaluated its public interest and see no public good in allocating land under the proposal for this development. Let me turn to my last point on public interest. The appellant makes the case that the provisions of first-class access to the South Downs National Park and to green space on the site. Secondly, provision for the forest school facility, and thirdly, provision for a scout hut are benefits to the community. Rule 6 admits that they're not a package of exceptional benefits at all, but they should receive no or at most neutral weight in the consideration. This is simply because they're not needed. As you will see on your site visit, sir, there's already ample access to countryside in the vicinity. Savills indicate on their own website, when selling properties in the town, that there are several forest schools locally and there are a large number of scouting facilities in the county. We'll leave this to the LPA to address specifics on the provision of Hazelmere itself. So in conclusion, the Rule 6 party is here to support the LPA and the appeal process. We seek to provide a local voice for consideration, and by you, sir, the Inspector, as you apply policy to the circumstances of this application. Our lay understanding of the NPPF is that there is a rebuttable presumption to refuse development on national landscape, and that can only be rebutted if there are, first, exceptional circumstances, and secondly, there is public interest in allowing the development. Objectors to the application and the LPA do not accept that the appellant has made a case for exceptional circumstances. It is the Rule 6 party's firmly held position that, whatever the planning position on exceptional circumstances, it is not in the public interest to proceed with the development. The cost of the harm and loss to the benefits derived from this protected landscape, its special character and the visual amenity are not outweighed by the purported benefits of a development proposal put forward by the appellant. We urge the Inspector to give appropriate weight to these valid community concerns. This development is not about meeting local housing needs, it's about profit. An opportunistic developer is forcing executive homes onto protected land, causing demonstrable and irreversible harm. Yes, housing is needed, but it must be balanced. This proposal is not. Thank you.
Thank you very much indeed, Mr. Brown. And yeah, if you could get a copy of that
Yeah.
over the break, that would be great.
Okay.
Mr. Cosgrove for the council.
Yes, thanks, sir. I'll have some written versions circulated, if I may, by my able assistant.
Thank you.
So, sir, if you're content for me to start.
Yep.
This appeal relates to a proposal for major development for up to 111 dwellings within the Surrey Hills National Landscape. The council opposes the grant of planning permission. So like you, I come to this fresh, having appeared the last time. As between the council and the appellant, the main issue is whether the appellant is able to demonstrate that there are exceptional circumstances and that it is in the public interest for permission to be granted. In other words, the 190 NPPF test. It is agreed that whether or not there are exceptional circumstances, as indicated in paragraph 190, is a matter that, quote, goes to the heart of the appeal. In short, as the council understands it, there remains no dispute, but that if there are not exceptional circumstances demonstrated, the scheme would not accord with the development plan as a whole. The application of the broadly drafted provisions contained in paragraph 190 of the NPPF requires an exercise of planning judgment and, in doing that, an understanding of context. I turn to landscape and visual effects and the national landscape designation. The primary basis for refusal and for continued objection at this inquiry is that the proposal would fail to preserve and enhance the landscape and scenic beauty of the national landscape. Indeed, it would cause, in the view of the council and the expert evidence it puts forward, serious harm to landscape character and in terms of visual effects, irrespective of the appellant's treatment given to the design of the proposal. The national landscape of which the appeal site is a part comprises some of Surrey's most outstanding and beautiful landscapes. In policy terms, it has the highest status and level of protection so far as landscapes are concerned in national policy. And so, as you know, the site is agreed also to be a, quote, valued landscape in NPPF 187A terms. It is critical that such nationally important places are safeguarded for the benefit of current and future generations. The main area of development would be located on rising ground adjacent to a consented scheme that lies outside of the national landscape and is near completion. It is an area of high landscape sensitivity. The placing of a major housing scheme on the designated land would change the character and appearance from one possessing key characteristics of the national landscape countryside to that of an urban environment. To service the proposed housing, a new vehicular access is required, which is proposed to run from Midhurst Road, which itself would be subject to tree removal and widening to facilitate a right turn lane. The council contends that the proposed entrance and related infrastructure, which includes a car park, buildings, road widening, tree removal and extensive engineering works and other development in the national landscape, would fundamentally change and in doing so adversely impact the existing rural character and appearance of the land around and near the road that exhibits, again, key characteristics of the national landscape. It is also currently part of the national landscape which forms an area indicating the start of the nationally important countryside as distinct from the more built-up area of Hazelmere. The proposed development within the areas identified in evidence, particularly as LCA 1 and 2, which covers around 5 hectares of national landscape and has agreed to be an area of high sensitivity, would result in a fundamental and adverse change in landscape character that would be in clear conflict with a range of development plan policies, the National Landscapes Management Plan, and up-to-date national planning policy. As we'll explain in evidence, the proposal before this inquiry is contrary to various policies in the NPPF, and in this particular context, in terms of 190C of the NPPF, would have a seriously detrimental effect on the landscape it is proposed to place it in, which would be permanent and which could not be moderated in a way that makes it acceptable. Although some improvements to parts of the larger red line site that the appellant has chosen for this application are proposed, they are not of a nature that could be said to offset the adverse harm caused by the development proposed. It is not in our submission credible to claim, as the appellant appears to, that there would be an overall beneficial change to the currently undeveloped land. We will, of course, need to examine the approach of the appellant that it's taken in this latest attempt to get permission, and in the evidence it has now produced in relation to landscape and visual effects. There appear, at least, to be some fundamental differences of approach and judgment as between the council and the appellant, and indeed as between the approach the appellant now pursues compared to the case it put before the inquiry last year. It is of note in this context that amongst the many detailed and cogent objections made by parties to this proposal, the Surrey Hills National Landscape Board has felt it necessary to indicate clearly that allowing this proposal would, quote, send shockwaves throughout nationally protected landscape bodies and the Surrey public. It is right to do so, as both the chair of the board and the Surrey Hills National Landscape Planning Advisor have made clear. There is no basis for finding exceptional circumstances existing here. The proposal would seriously harm the natural and scenic beauty of the national landscape in a way that is wholly objectionable. As the board have correctly identified, quite apart from the policy tests which are plainly not overcome, the inquiry will also need to consider the statutory duty in Section 85 of the Countryside and Rights of Way Act 2000 as amended, which requires the decision maker to, quote, seek to further the purposes of conserving and enhancing the natural beauty of the national landscape. It is plain that the proposal is not consistent with the promotion of such statutory purposes, and a grant of permission would not be in accordance with that duty. There is simply no cogent justification for such a proposal. More recently, in December of last year, statutory guidance has been produced by the government, and early in the new year, January of this year, the government produced new planning practice guidance, emphasising the importance of delivering the statutory purposes of national landscapes, and you'll find that reference to Mr. Johnson's proof. Then I turn to context and balance. So, as I indicated, of course, the decision needs to be made in context. Para 190 of the NPPF provides in my submission a point of reference for consideration of at least some of the context, as of course does the consideration of relevant development plan policies and the statutory provisions and new guidance I've already briefly addressed. Much is made, and my letter friend hasn't let me down, much is made in his opening, but much is made by the appellant of the current lack of a 5-year housing land supply. And it is a matter of common ground that the Council, in light of the new requirements to calculate need, has currently only a 1.28-year supply. But the appellant singularly fails to put that in context. The new government planning policy context makes it clear that the importance of delivering increased and much needed housing must now, more than ever, focus on how and where it should be delivered. In simple terms, that should not, except in exceptional circumstances and where it's in the public interest, be in national landscapes. Rather, the imperative and message from the same policy context, when fully understood, that has identified a greater need for housing now, is to deliver new housing on brownfield land, or if not there, then in the areas yet to be identified, or which, as here, currently being identified in the local plan reviews now starting as grey belt. At the same time, the importance of the strengthened duty on decision makers to further the purposes of national landscapes has been supported by this government and reaffirmed in new guidance. Moreover, it has been emphasised that decisions as to where housing should go should in principle be plan-led. Decisions on major developments in national landscapes which seek to grapple with Para 190 NPPF matters are not in many regards as suitable a forum as a plan-led context would be in deciding whether houses should be built in such an important area. This council has already recently approved a timetable for a new local plan to take into account the new policies of the government, which will lead to a new plan by around July 2028, and an emerging evidence base for consultation well before then, and well before any meaningful housing could actually be delivered by this proposal. Quite apart from all that, the new plan-led requirement may, given the acknowledged constraints, result in a materially smaller requirement than the current calculation of need indicates. That is a point clearly made in up-to-date government guidance, as is the point that national landscapes are unlikely to be suitable areas for accommodating unmet needs from nearby non-designated areas. It is highly material to context and an assessment of whether there are in fact exceptional circumstances to justify harming the national landscape. This context then, sir, needs now to inform the consideration of NPPF 190, and it matters. Moreover, not only is it relevant to understanding the, quote, national considerations in 190A of the NPPF, it also underpins and delineates the ability of a Section 78 appeal to grapple in any meaningful way with alternatives in the broader context of the cost and scope for developing outside the designated area, or of meeting the need for it in some other way. The debate as to alternatives and evidence typifies this. It is in many senses an artificial one in this context, and no doubt, sir, the inquirer will hear numerous arguments as to approach. But when it's grappled with and a common sense planning judgment applied, in essence the matter is simple. Given the current government policy context, which seeks to emphasise that we should build houses elsewhere from national landscapes, it would be artificial for the inquiry to assume that the only sources of supply are those which it is possible to identify at this time, nor is a decision maker required to do so. A full review is underway and a call for sites is ongoing in light of the recent policy changes. There will clearly be opportunities for further sites to come forward through the local plan review process and scope provided for housing in such sites. But even if one did proceed on a narrow assumption in relation to the current, quote, alternatives put before the inquiry, it appears in fact the appellant doesn't suggest that the position is materially different from the last inquiry, where it was in the end accepted that there are indeed sequentially preferable sites, at least if one assumes the relevant question is whether there are sites in the district capable of delivering a similar quantum of development. That is, the council suggests, the appropriate approach to take, to the extent there's a debate about alternatives as one part of a wider consideration of factors in 190 NPPF is going to actually assist you at all. The council, through Mr. Johnson, has considered the up-to-date position and undertaken a planning balance. The council will explain that it considers there to be conflict with a range of development plan policies and with the development plan as a whole. In particular, the council contends there will be conflict with policies SP2, RE1, RE3 of LPP1, and policies DM11, DM15 of LPP2, and policy H9 of the neighbourhood plan. Further, there are a number of material considerations which weigh against the appeal proposal. The proposal will cause unacceptable harm and would not be outweighed by the benefits put forward, in relation to which it appears there are elements of, we say, some double counting by the appellant. Exceptional circumstances just do not exist. Para 190 of the NPPF is not satisfied, and the evidence provides a strong reason for refusal. So beyond those matters which are in our submission easily sufficient to dispose of this appeal, it is important, and we say obviously material, to note that the previous inspector's decision, which was dismissed at appeal, is less than a year old, and of course considers the same proposal. The council submit that the basis for quashing of that decision, which was because of a procedural error, has nothing at all to do with the reasoning and findings made by that inspector on the various issues he grappled with relating to exceptional circumstances. His careful consideration of landscape and visual matters, of alternatives, and of other considerations is highly material now as it was then. As a decision, even though quashed, it is in law capable of being an important material consideration. So I've set out at footnote 12 the particular case law we're going to draw in due course in case you have a sleepless night and you want to look at it ahead. NID 7.37, the Elmbridge case, the judgment of Mrs. Justice Thornton, which is then subsequently affirmed in Kinnersley, which my learned friend referred to, are two cases we're going to invite you particularly to look at within the court documents. So as a decision, even though quashed, it is in law capable of being an important material consideration, not least given the importance of the principle of consistency for public confidence. And obviously, it's one for the purposes of this appeal in our submission. It weighs heavily against the grant of permission. Indeed, since that decision, if anything, the new government policy amendments and guidance, when understood in context at least, have made the importance of protecting national landscape from proposals such as this one even clearer. It would provide in any event, a yet further basis and a balance for dismissing this appeal, and we submit requires careful consideration. And so in the end, we'll submit that this appeal should be dismissed.
Right, thank you very much for that, Mr. Cosgrove. Right, we'll take a just about mid-morning. We'll take a mid-morning break in just a second. Some document copying, and just remind local people who want to speak, if you have got any documents, could they be given to the council ASAP? When people do speak, I'll ask you to come up here. We need you to be on mic and visible. So if you can come up here to speak. Once you've given your statement, depending on which way you go, it may be that the other side will want to ask you some questions. I don't know. And it could be one of three sides who might want to ask some questions. Let me just be absolutely clear about this, because there was some concern expressed at a relatively recent stage in correspondence. People who speak don't have to answer questions. The questions will be courteous from all sides, and guarantee that. They will be polite. You do not have to answer questions, but, and this is an important but, I have to give slightly less weight to evidence that is given by local residents if you don't answer questions. If it's not tested, I have to slightly reduce the weight. I'm only really raising that. I don't normally do it at inquiries, but simply because there was a bit of concern raised, I think it was by Ms. Brown, and maybe, yeah, that some residents were concerned that they would be subject to a grilling if they gave evidence. You won't be. Whichever way you're giving the evidence, that any questions will be polite and courteous, and you don't need to fear from them. Okay, all that said, it's now 10 to 12. Can I just have a show of hands? Anybody who wants to speak who is going to ask for some copying to be done? Anybody got any copying to be done? Not that many. Shall we give it till 12:15 just to get the copying done, if that's possible? So we'll resume 12:15, then perhaps carry on till about 1:30 for a lunch break. As to who goes first in terms of local residents and others, it's entirely up to you, but perhaps somebody could sort of volunteer when we start off at 12:15, so we don't all sit here waiting. So 12:15, please. Yeah. Those are the changes that you made.
Yeah. Just email it rather than print it.
Could we just have a?
Oh, sorry, I should have.
Could we please, again, don't want to keep asking. I know that you're some way back in the public gallery, but the sound does travel because I think it's the angle of the roof, and it's quite disconcerting if I'm getting a discussion in my ear. Sorry, Mr. Brown.
I was saying, would it be easy to email this round to everyone rather than photocopy it, because I've got some changes?
Were they the changes that you read out? Yeah, that might be the easiest way of doing it.
I'll do that.
I mean, I made a note as we were going on, but yeah, if you can do that by email, and there's no immediate rush on that, obviously. Okay, 12:15 then, please. One of them was Mr. Clive Smith, who's the Surrey Hills National Landscape Planning Advisor. He'd indicated he wanted to speak and was very concerned he could be on first. But anyway, I understand for personal reasons he can't attend, but the suggestion was that somebody would read out the statement that he wanted to give. I mean, I'll see what the parties think about this. I'm in two minds. I mean, we could either, I certainly want to hear what he has to say or read what he wants to say. The only statement that I've got from him to date, 11th of March by email, I'm not sure if that's what is wanted to be read out. So I'm in two minds as to whether we hear it or simply ask it be submitted in writing. Any thoughts, Mr. Morici?
Well, I mean, I don't have a strong view on it, but my view is, it's better to just be submitted in writing. There are other things that are just going in writing. It doesn't add any weight to the evidence if it's read out compared to in writing, because he's not here to answer questions. I mean, he didn't attend the previous inquiry either. So I don't think it makes any difference in terms of weight. So that's my view, sir.
Do we know, is it his 11th of March email that was being talked about, or is it something else?
It is
It's
apparently,
either-
yes. So
Right. Well, in that case,
yeah. So I
Let-
think if we could just note that he had hoped to be here and
It's
has
the
said
11th.
he personally cannot be here.
I'm not
and
looking
I
askance
take your
at
point
him
about not
because,
being
yeah,
cross-examined. So
Mhm.
as long as it's submitted because they are a body of some authority. Thank you.
indeed, which is why I wanted to pick up on it. And I
A
mean,
statutory consultant
I-
as well. Yeah.
and certainly the fact that he's not able to be here for whatever reason, that's not a black mark in my book.
Fine.
Yeah, I'm looking at his 11th of March email, and
That's fine. Thank you.
can we remember mobiles, please? Yeah, I think what I'd ask, and I'm just thinking out loud in terms of submissions and core documents, I'm assuming that the council has got the 11th of March email. If not, the inspectorate can provide it. I'm sure you have got it. But could we make his 11th of March email, not the top and bottom bits, but can we make that a document submitted to the inquiry? I mean, I think we've all got it.
Yeah, so we'll check. It might already be in there actually, but I'll check. I'll check.
That I don't know. I'm
We'll
looking
check
on-
and see.
Yeah.
We'll check and see.
If it's not in there, let's get it in there as
Yeah.
a written submission.
We'll just put it in well, so everything that's come in, including people who are going to speak today and have handed in speeches, we're just
Yep.
going to put those all in the in the inquiry documents.
Yep.
Yep, that's fine.
Whole lot.
So we'll put the 11th of March one in there as well.
That's probably the best way of dealing with it. Okay, thank you very much for that. Right. Has anybody decided they would like to go first in terms of, yes, so if you could come up to the front.
These are copies.
Ah, okay, could I? Sorry, I'm a bit trapped in here. Thanks. Yes, sorry, my apologies, I looked down.
So is there more than one copy? Sorry, what was your name?
There are 4 copies.
Oh, 4 copies there, are there?
Oh, I'm sorry, I hadn't even looked at it. Could you distribute? Yeah.
You got them.
No, I haven't yet. Thank you. Just bear with us just a moment whilst we
Sure.
hand these round. Okay,
Okay, good afternoon. My name is Robert Coombs. I have been a resident of Hazelmere for some 31 years. I have to start by asking respectfully the question, why is there a second hearing? Following the clear decision by the previous inspector to reject the appeal on the grounds of not meeting the exacting criteria of exceptional circumstances, its negative impact on the landscape, and it not being in the public interest. The fact that the previous inspector made a comment prior to the first appeal by liking correspondence from the appellant that appeared to be favourable to them, this was challenged by myself and numerous residents on the grounds of impartiality during the first appeal process. With the appellant's full knowledge, they were prepared to allow the appeal process to proceed. But when receiving a rejection of their appeal, the losing appellant runs to the High Court, stating that the administrative error had been made and that a decision was unbelievably quashed by the judge. I just wonder if they would have taken such action if they had won. But what bearing does this have on this decision to reject the appeal? If, in my view, none of the original inspector's decision would stand avoiding the significant costs of a second appeal. In the event, and you, I'm sure, will insist on the second appeal proceeding, there are countless reasons for again refusing permission for this phase 2 planning proposal, such as the environmental damage concerned. The recent felling of 150-year-old trees to facilitate an entrance to the site that has not even had planning permission, in my view, is disgraceful. The lack of infrastructure, doctors, schools will all be impacted, and the impact on the landscape, quoting Tom Bristow, the first inspector's comment, causing considerable and serious harm. You may not be aware of the long-running water crisis that currently is being suffered by Hazelmere, courtesy of Thames Water, where the only way to ensure water supply to the area is to have water tankers feeding the Blackdown Reservoir. Remember, this is phase 2 of 4 phases proposed. If allowed to proceed, this will become one of the largest housing estates in the local area. You are already aware of the issues with unprecedented number 500 letters of objection received at the beginning of this appeal by local residents. You're also aware this proposal has been rejected by both Waverley Borough Council and Hazelmere Town Council and is outside the local planning area. Again, quoting Tom Bristow's concluding remarks, there is clear reason for refusing permission with reference to NPPF paragraph 11.d. I want to highlight that this is a site of outstanding natural beauty. I'll repeat it, an area of outstanding natural beauty and also an area of great landscape value, and question why governments bother to spend so much time developing these designations and making laws which are designed to protect the land for future generations from profit-driven developers, when these laws can so easily be circumvented by clever lawyers. To my mind, this appeal decision is clear. Does the proposed development meet the criteria set out in the area of outstanding natural beauty and area of great landscape value laws? These rules state there must be exceptional circumstances for any development to occur on these protected lands. Please ensure that you apply the maximum weighting to meeting the exceptional circumstance laws when judging the pros and cons of this proposal. And for the avoidance of doubt, there are no exceptional circumstances. I'll repeat that. There are no exceptional circumstances, despite what the the lawyers may tell you. I appreciate that in reaching your decision, you will have to contend with the previous inspector's full and fair analysis and his conclusion to dismiss the appeal, as it does not meet the exceptional circumstances criteria, will cause great harm to the character and the landscape of the area, and therefore it is not in the public interest. I therefore fully expect you to dismiss and reject this appeal for the sake of both current and future generations of Hazelmere. Thank you.
Thank you very much, Mr. Coombs. Any questions, Mr. Morici?
So I have got
Are you happy? Sorry.
No, sorry. I have got a couple if he's
Both have to answer. Okay, yeah, Mr. Morici.
Mr. Coombs, first of all, are you a member of the Hazelmere South Residents Association?
Yes, I am.
And are you a member of the Hazelmere Society?
No.
Thank you. You accept, I assume, do you, that there is what the Secretary of State's referred to as an acute and entrenched housing crisis nationally in this country?
Yes, I accept that.
And you accept that locally there is an acute need for more housing. This is one of the least affordable places to live in England, correct?
I'm not able to comment on that.
You don't know. Okay. Now, there's also, would you accept, an acute need for affordable housing in this area, correct?
I do.
Yeah, thank you. Now, can I just ask you some questions?
Can I ask you a question?
No, you cannot.
What is your
No,
definition
no,
of affordable housing?
No, you cannot ask me a question. That's not the way it works. Sorry. That's just not the way cross-examination works.
Yeah.
I ask you the questions.
If you're not clear about what the question means, by all means ask the question to be clarified. But
Okay.
you actually did answer the question. So Mr. Morici and I are in the fortunate position that we don't get to answer questions. But if at any time you're not sure what the question means, ask for clarification.
Okay. Now, can I ask you some
Well, for
questions?
clarification, what is your definition of affordable housing?
No, well, I'm not giving you a definition of
Okay,
affordable
you
housing.
don't want to answer.
No,
Because
no.
the houses-
Excuse
Okay,
me.
whoa. Gently, please. I was trying to be helpful. It's question and answer, question and answer.
Okay.
You don't, I'm afraid, get to ask the question back.
Fine.
Sorry.
Right. If we proceed with the questions, on your statement, please, I need to pick this up with you. On the first page, third paragraph from the end, you refer to the recent felling of 150-year-old trees to facilitate an entrance to the site. And then you referred to, I think you used the word disgraceful and planning permission. Who removed those trees?
Surrey County Council.
Right. And why did they remove those trees? You've looked at their documentation, I assume, to understand why they removed them.
There was a claim that they were diseased.
Well, so there's a claim that they were diseased. The Highway Authority removed them because they believed that they were diseased and dangerous, yes? That's what they said.
If that's what you're telling me, I didn't speak to them.
No, but why are you...
Who asked them? Who
Well,
asked them to?
Sorry to interject again. If the answer is you don't know, then just say, I don't know. We move on.
We can move on because obviously Mr. Brown made a similar statement when he opened, and obviously there's an inference sought to be drawn. I fear that either we did it or it was done for our access, but it wasn't because the county council have said it was done
Mr.
because the trees were
Morici.
unsafe. Well, okay, I'll move on. Can I ask you, yeah, just one other thing. I think just one other thing, yes. You referred to phase 2 of 4. Do you remember you said this development is phase 2 of 4? Do you remember you said that?
There are, in the overall proposal for this Scotland part, there are 4 phases
Where
that
do
were
I,
originally proposed.
where's the best place to see that? Which document have you got that from? Just so I can understand how you've come to that. I just need to know where you saw that.
At the open day that they had, they identified 4 phases of development for the park.
So just to help me, is there a document that you know?
Yes, I have a copy of that document, not with me, but
All right. Okay, fine. You don't know whether it's in the inquiry documents we've already got before the inquiry. You probably haven't looked at them all. I don't blame you. There's a lot of them. So you don't know whether it's before us already, do you?
I saw it at the original open day that they had. They had proposals for 4 phases. This is phase 2 that we're talking about today. I believe there's a further 3rd and 4th phase to come.
Okay. And I suppose I should just ask you at the end, you've signed your name and you've given your qualifications, engineering. You're not an expert in matters of planning or landscape, are you?
No, I'm not.
No. Okay. Thank you very much. Those are my questions, Mr. Coombs.
Thank you very
Thank
much,
you.
Mr. Coombs. Can we, before we hear from the next person, that matter of 4 phases, could I leave that particularly with the council and the appellant, just to see what we can come up with in terms of 4 phases at the original open day and beyond? I mean, I say that, not that I'm necessarily hanging much on it,
No.
but I think it was news to me that there are 4 potential phases, or there were 4.
Yeah.
Okay,
Excuse me, I do know the answer to that if it helps.
let's go for it, see if we can bottom
When
it
the
out.
original was set out, the land was broken into several parts on paper, and they had some offers, I think, of buildings on the Belvale Lane, which is the very south part, and they were later removed, or quite quickly removed. So it was only ever 2 phases when it came to planning and appeal.
Do you have the original 4-phase document?
It was in a presentation they did,
Yeah.
but
Okay.
I probably have, because I collected most things. I can have a look.
Let's leave it with all,
Yeah, I'm
all
just saying it's
3.
there.
If anybody can shed light on
Yeah.
that, that would
But
be.
as far as I know, the other 2
helpful.
phases were removed.
Okay, who wants to speak next? Yes, one of the ladies at the back, don't mind who. Have we got a copy of your? Sorry, what's your name? I'll find it in a minute. Yeah, bear with me a second.
Sorry, so I missed the name for the purposes of finding the documents from our bundle.
My name's Jan P.
Is it me? Can you put the mic on?
Marichi's got a copy. If you can give it, you have,
Can you
great.
put-
I didn't know whether they've been sent.
Oh, yeah, below the yellow. That's it. Sorry, I don't have a copy of that. Other people got it?
That's the one. I'll pass it on right.
That's me.
Yes, sorry, I thought I had a,
We'll listen and we'll get a copy later on.
yeah, okay, yeah,
That's the
definitely.
one. I think that's your one. Yes, yes.
We've got it, right,
Yes, that's good. Yes, okay.
okay, that's absolutely fine, thank you. Right,
Okay.
yeah, sorry about the hiccup.
That's okay.
Yeah, if you can introduce yourself and read your statement.
Okay. Good afternoon. My name is Jana Hearn and I've been a resident of Belvale Lane for 18 years. Today I would like to talk to you about the landscape character of Belvale Lane. For some context, Belvale Lane sits at the southern border of this proposed development. A stream runs down the length of the lane, and this is broadly the Surrey-Sussex border, meaning that the lane sits within and is a gateway to the South Downs National Park. The land that borders Belvale Lane on the Surrey side has been designated AONB land, or National Landscape as it's now called. The proposed development sites within this land a gate lodge, a car park, and potentially, depending on the to be confirmed siting, a scout hut and a forest school. In addition, the developer proposes the creation of ponds, wetlands, and new gravelled footpaths. Belvale Lane is a beautiful, tranquil, characterful rural lane. It is very windy, very narrow, single track bordered by streams, trees, and hedgerows with a number of blind bends. Passing places are few, and its residents are adroit reversers. Of the 30 or so houses on Belvale Lane, 4 are listed with Historic England. It is bordered by National Trust land that was gifted by local residents in the 1990s, who fundraised it to buy it for the nation to provide a gateway to Blackdown, the highest point in West Sussex and inspiration to the poet Tennyson. At the end of the lane is a wetland habitat currently being enhanced further by the introduction of a pair of beavers by the National Trust. The soundscape of Belvay Lane is a gentle trickling of the stream, the wind in the trees and birdsong. The lane has high scenic amenity. As I stated earlier, it is beautiful, characterful and tranquil. It has an abundance of public footpaths, including the Sussex Border Path, bridleways and green lanes. These existing amenities on Belvay Lane are widely used already by the residents of Belvay Lane, the wider Hazelmere community, people from wider afield visiting the beautiful area for day trips or holidays. We get dog walkers, long distance walkers, families, large rambling groups, Duke of Edinburgh participants. We get mountain bikers, horse riders. You get my drift. So, contrary to how this planning application reads, the connection to the national park for the people is already there. The infrastructure already exists on Belvay Lane and is well used. Therefore, the community benefit of providing this gateway, as per the proposal, is of zero weight. The wheel, in this case, has already been invented and is running very nicely. Belvay Lane is rich in flora and fauna. Spotted orchids and other wildflowers can be seen growing along the edge of the lane. Dormice inhabit the area, and in our garden alone on a daily basis, amongst others, we see marsh tits, bullfinches, donnocks, song thrushes and lesser spotted woodpeckers, all on the government's own red list of birds of conservation concern. The occasional kingfisher can also be glimpsed flying on the lane. The nature on Belvay Lane does not need man-made enhancements. The developers proposed improvements of gravelled paths, artificially created wetlands, etc., may enhance a city park, but not a pre-existing, naturally wild area that is already rich in such habitats. It is not needed, and one could argue that it would destroy more habitats than it actually creates, leading to a decrease in biodiversity on the lane. In short, nature has already built what it needs on Belvay Lane. The developers' proposed improvements are no such thing from a diversity perspective. Opportunities for learning by observing different habitats and exploring and getting out in nature already exist and are enjoyed by the community. A specific forest school classroom or scout hut is not needed to experience on nature on Belvay Lane. A pair of wellies and enthusiasm is all that is needed. The creation of a car park on a single track road, as proposed by a developer, that cannot accommodate an increase in traffic numbers and destroying AONB land in the process also does not benefit the community in any way. The developers propose man-made creation of ponds on land that borders Belvay Lane by bringing water down from ditches on the top of the land that overflows into the stream on Belvay Lane is ill thought through. The stream already breaks its banks, flooding Belvay Lane numerous times a year. This will make an already problematic situation worse. Landscape are made up of everything you see, hear and experience. The landscape of Belvay Lane is special. It is a place that makes you feel better. Its visual enjoyment improves mental health. Its networks of paths and bridleways encourages active lifestyles already. Nature is not only recovering, but is thriving in Belvay Lane. The flora of Belvay Lane contribute to managing climate change. In conclusion, the developers' proposals for Belvay Lane will destroy rather than enhance, regardless of the claims, and have zero community benefit. Many thanks for taking the time to listen to me today.
Thank you very much. Anything, Mr. Marici? You okay with the question?
I'm fine with it, thank you.
Are you a member of the Hazelmere South Residents
Yes, I
Association? And the Hazelmere Society?
No, I'm not.
Okay, thank you. I just wanted to ask you, I think, two things. First of all, on your second page at the bottom, you refer to the creation of a car park on a single track road, by which you mean Belvale Lane, correct?
I was only speaking about Belvay Lane, so I did not make that clear.
Well, you could just say yes or no to my answer.
I could do, yeah.
Was that a yes?
It was a yes.
Thank you.
Thank you. There's no car park proposed on Belvale Lane.
If you look at the developers' brochures, it says a gate lodge and a car park.
Those are on Midhurst Road.
And on some of the documents I've seen, if you Google Scotland Park and the brochure that comes up mentions a car park.
Right. Well, have you actually looked at the plans which are submitted for the purposes of obtaining planning permission rather than just doing a Google
I
search?
have, but as a layperson with no technical ability wading through,
Right.
it's been very
So,
difficult.
given that there is no car park proposed on the single track road, presumably we can just scrub out that last paragraph.
Yes, if that's no
Yeah.
longer
All
relevant,
right,
yes,
thank
of
you.
course.
Well, no longer, it never was proposed. I don't know. I mean, anyway, it doesn't matter. It's not part of the planning application. Now, finally, can I just ask you this? You are not somebody, are you, with any expertise in planning, landscape or ecology? Is that correct?
A keen interest,
Right, but no
but no
expertise.
actual
No.
expertise, no.
Right, thank you very much. Those are all my questions. Thank you, sir.
Okay, thanks very much for your
Thank
time.
you.
I think, yes, the other lady at the back wanted to. Oh, that's the opening. That's great. Thank you. Hello. Have you? Okay. Sorry, what I was saying. Right, do we have a
I am
statement, a
Jane,
written statement?
I'm Jane Devlin.
Yeah, do we have a written
I'm
statement?
going to email it because I've added a couple of extra things.
Right, okay. Right, if you could introduce yourself, and yes, just in case anybody didn't catch it, there's going to be an email statement coming round because there've been a few changes. Okay,
Thank you. Can everybody hear me okay? Thank you. What a lovely day. My name's Jane Devlin, for those people who don't know me. I don't live in Hazelmere, I live in Chiddingfold. I do, however, have great connections with the town of Hazelmere. I have been the treasurer of Transition Town Hazelmere for maybe a decade. Doesn't time fly when you're enjoying yourself? I'm also a beekeeper at the Hazelmere Educational Museum, looking after bees. And I'm a parish councillor in Chiddingfold. So although I am a layperson, I do use the planning policy framework to make comments, and I'm familiar with the way the system ought to work. My opinion of the planning policy framework is that it should be reliable and have the confidence of residents so that any adopted policies can be interpreted by a layperson such as myself. It's there to provide an easily understood, referenceable framework and expectations about development, especially the sustainability of development. And I wrote this down, so I'm going to read it out. Sustainability, to me, and it's a very classic definition, is to meet the needs of the present without compromising the ability of future generations to meet their own needs. And I agree with the previous two speakers on this, so I won't go into any more detail. In fact, sir, we are part of the same system. I am a parish councillor and I make comments on planning applications in my local area. You're slightly more elevated than I am. But each of the relevant policies and plans in the whole process have been meticulously drawn up by professional planners, scrutinised, consulted upon, inspected, and we have referendums for our neighbourhood plans. These are not trivial documents, they're not trivial policies, and they give us confidence. They are material considerations and should be enforceable. So I'm very pleased to be part of that process today. I've never done this before in my life. I'm quite nervous about it, in case you hadn't noticed. The Waverley Borough Council Local Plan Part 1 states that the council will work proactively to secure sustainable development that improves economic, social and crucially environmental conditions in the area. The Local Plan Part 2, SP2 policy, is to maintain Waverley's character whilst ensuring development needs are met in a sustainable manner. And also to avoid major development, I'm quoting this, I'm sure you've read it, to avoid major development on land of the highest amenity value and of landscape value, such as the Surrey Hills. Policy RE1, criteria little I, landscape character, actually says to enhance the distinctive character of the landscape in which it is located. And it goes on to say that the Surrey Hills is a landscape of national importance and references the Surrey Hills Management Plan. In the Local Plan Part 2, DM11, which relates to the trees and woodland and hedgerows, and I'm thinking specifically of the Midhurst Road Avenue, which is absolutely beautiful at this time of year, actually all year round. Firstly, to retain woodland and important trees, and secondly, to protect trees. Under policy DM15, this relates to areas which are outside the settlement boundary, which I believe this one is to recognise the natural beauty and undeveloped character which is intrinsic to the open countryside. If I go down a level to the Hazelmere Neighbourhood Plan, which actually I had a tiny help in the Hazelmere vision at the very beginning. This also has a policy H9 on trees, woodland and hedgerows. And it does say that development would be supported where they conserve and enhance trees, hedgerows and woodlands of value. And development proposals must avoid damage and loss of mature trees or semi-mature trees. I don't think, as the first speaker said, that there are any exceptional circumstances. In policy H1, the settlement boundary, development outside the settlement boundaries will be strictly controlled. So before I come to my my closing statement, the two things that I wanted to add, first of all, was the reference. So I'm a parish councillor in Chiddingfold, and there is a reference to a development called Queensmead, which apparently is a precedent for building in the national landscape. I can tell you that that plot was included in our neighbourhood plan, so it was voted upon and became part of our development plan, and it's also within the settlement boundary, so it doesn't really bear any relation to the case in front of us. I think I would like to quote the previous inspector that collectively the benefits of this scheme are not sufficiently compelling to justify the harm that would result. Allowing the appeal would not be in the public interest, and more than that, it would shake the very foundation of the confidence that the public has in the planning system. I think it would set, as the Surrey Hills management have, it would set a dangerous precedent. I think they used the word shockwaves, but I think it would set a dangerous precedent in favour of unsuitable development in protected landscapes across the country. Thank you.
Thank you very much. Mr. Ricci, any questions? You okay with questions?
I am okay with questions.
just a couple of things. Can I just understand, you talked about being involved in Transition Town Hazelmere. That's different from Hazelmere Vision, is that right?
Yes, actually an international.
Oh, I see.
It's aimed at moving to a low carbon thriving economy based on local networks.
Thank you. And then can I just ask you this? You mentioned Queen's Mead, which was, I think, as you said, allocated in the neighbourhood plan
The
for
Chiddingfold neighbourhood
Chiddingfold
plan,
neighbourhood
yes.
plan.
And I only mention it because it was referenced by one of the parties here.
Yes, indeed. That's the subject of an application for planning permission as well, isn't it?
No, they're
Been granted.
It's underway.
Underway.
It's underway.
So but that site, when it was allocated, and indeed even now, is part of the national landscape, isn't it? It's within the national landscape.
It's also within the settlement boundary
Yeah.
of Chiddingfold, and it was in our neighbourhood plan that went to a referendum
Yeah.
and accepted.
But if it's in the national, it is in the national landscape as well, yes? That is where it is.
But it's within
Well,
a settlement boundary. So yes, but it's
yes,
within
okay,
a
yes,
settlement
but that's
boundary.
fine. Yes, but is fine. Thank you. Okay, and then to the extent that that development is classified as major development, which it is, it would have to meet the same tests as our scheme, wouldn't it?
Not if it's in the neighbourhood plan
Well,
and I'm a layperson,
no, okay,
but
right.
our opinion at the parish council is that it was in the parish neighbourhood plan that was adopted through a properly
Yep.
performed referendum, and it is within the settlement boundary. It's infill
Yes,
and does not have an impact visually on the landscape.
well, I mean, as I understand it, when it was allocated, it was taken out of the green belt as well, wasn't it?
Do you know Chiddingfold?
Sorry, can I answer my questions? It was taken out of the green belt as well, wasn't it?
So there are always changes. I'm a layperson. I'm not a planning expert.
I'm not going to pursue any.
But there are
Do
changes
you know if it was
to,
taken out of the green belt?
there are changes to the green belt. Ongoing.
Try again. Do you know if it was taken out of the green belt? If you don't know, just say you don't know.
I don't believe so, but I don't know.
Okay, that's fine. Thank you.
I'm not going to pursue it any further, so I can deal with it with other witnesses. Thank you.
Okay, thank you. Thank you very much.
Thank you very much, and thank you for your questions.
Who? Right. It's just one of the sheets that I've got. Danny Page. Got you. Okay, fine. If you could just introduce yourself and read your statement. Thank you.
Good morning. My name is Danny Page and I live in Scotland's Close, and most of our properties are adjacent to both phase 1 and 2 of the developments. This means we are probably the most obviously affected residents by the proposed development. And as such, my presentation is thus focused and does not mean my total support for protecting our natural landscape is diminished. Already, I have had to fit an obscuring film to my daughter's bedroom window, as the construction workers and potential residents can look straight in due to the top floor windows of the building being constructed being in direct line of sight of said window. The 130, I put that because that's a figure that's been quoted, new houses to the south will be far more intrusive. I would now like to highlight the very real existing problem of flooding from runoff, which occurs when concrete and tarmac take over our natural green spaces, and also the far-reaching concerns of this situation for the local community. At present, we at number 9 and 10, Scotland's Close, have floodwaters from the Olivia Homes phase 1 development and also from the phase 2 area. This is entering the corner of number 9's garden, which then streams down through their established lawn into mine at number 10. This in turn cascades over a retaining wall, encircles my detached garage and streams down the drive into Scotland's Close. joining the water already streaming down Scotland's Lane and flooding at the end of the road. This flooding is well documented and filmed. When the first garden flooding incident occurred in January 24, it was during a severe rainstorm at night. I filmed as much as I could on my phone and went straight round to the site office of Elvia Homes the next morning and explained my concerns to the then site manager, who walked me across to where I felt the water was entering our gardens. After some discussion, he agreed to dig a trench as a temporary fix, which incidentally never happened. This being temporary as the roads and drainage construction was still ongoing, and he felt the problem would likely disappear. It did not. I also decided to contact the council's planning enforcement department about the problem, which, while informative, did not help, as they felt it would be covered by flood control if the problem persisted once the development was complete. The flooding has happened 3 more times, and each time I visited the site and spoke to the site manager, he informed me the problem had been reported to his immediate superiors. The phase 2 development of 130 residential homes will be nearly 3 times the size of phase 1. My house, like many in the close, is built into the side of the hill and at present has a perfectly dry basement. So I have great apprehension as to what will happen in the event this unnecessary blight to our natural green space and amenity view is allowed to be built. The proposed properties will be up to 6 metres above, blocking natural sunlight, and if the initial phase 1 is an example, the ground will be levelled against each block of houses, as I believe new buyers will only take on flat level lawn areas. This will exacerbate the flooding further on the Scotland Close properties, which cannot be resolved by the use of SUDs. There are no exceptional circumstances, real or dreamt up, which would benefit the local residents. So hopefully these proceedings will lead to the end of this waste of time and money for good. Sir, thank you for your considerations, and I ask the inspector to reject the appeal.
Thank you very much. Anything from you, Mr. Marici?
Sorry, can I just check, sorry, Mr. Page, are you a member of the Hazelmere South Residents Association?
I believe I am.
You believe you are. And what about Hazelmere Society?
I'm not.
You're not. Thank you very much. And can I ask, have you lived at Scotland's Close for a long time? Roughly how long?
No.
No, you're new, relatively new. Are you?
Yes.
Okay, thank you very much. Those are all my questions. Thank you, sir.
Okay, thanks very much for your time.
Thank you.
Thank you. I got your.
In fact, I'm going to not repeat what other people have said.
Okay, that's much appreciated. As soon as I can find your statement, I will.
It looks like that.
Ah, hang on.
The one.
Yes.
Sorry, can I
get your
name?
Maggie Hamilton.
Okay,
Thank you.
floor is yours.
Thank you. My name is Maggie Hamilton. I have been a Hazelmere resident for 45 years and lived in Scotland Lane for 20 of those years. I am not going to repeat what other people have said, though I agree wholeheartedly with what they have said. All I would add is that SHAOB is solely concerned with the natural environment and no development can enhance it by definition. Whatever happens, there will be damage and irrevocable damage to footpath 597 and indeed to the Midhurst Road outside the development, as it is a sunken country lane currently with a canopy of trees and banks that are higher at the site. It marks the end of Hazelmere and the beginning of a more rural part of the countryside. It will not, once it has been widened and more trees have been felled. I walk dogs, children, along the footpaths and the very many footpaths we have access to onto Blackdown and other areas of the National Trust. And we don't need any more artificial footpaths, in my opinion. I would like just to state my objection to the proposal. Thank you.
You okay with questions?
Yeah, sorry.
No question, no
No
questions.
questions. Okay, thanks very much for your time.
Okay.
Can I just pick up on something? Whilst that witness was giving evidence, the camera was still on Mr. Morici, which is fine, nothing personal, Mr. Morici, but does it automatically come round? I hadn't noticed that before.
Should follow the mic, I think.
Yeah, but if there's two microphones on,
Oh.
it'll be okay. If there's more than two, it might struggle to.
So it's Mr. Marici's fault. Okay, that's fine. I'll live with that. All right, thanks very much. Right, who would like to go next? Yes, sir. Sorry, I just spotted that. And thought- Okay. Yeah, it's moved round now. Sorry, it was just, I thought it was going to look rather odd for people on the live stream, but that's fine. They could hear anyway. That's the most important thing. Yes, sorry, you are.
Michael Bradford, or known universally in Hazelmere as Mick. Mick Bradford. I've done many jobs. I've been a resident there for 65 years now, and I can honestly say I've walked every inch of Hazelmere and its surrounding area. Know it reasonably well. I just come from an aesthetic point of view. I mean, I've looked at all of this from every perspective. In my role as a pilot, I have flown over it. It's the most beautiful area and one I really love. I mean, it's something special, and it comes as a complete package to me. So anything that happens to it affects me deeply. Now, the reason I say this is because to me, it's a jewel in a crown, which is the National Trust that surrounds it. And the historical part of this is of great interest to me. I think what I wanted to say was that not a lot of people know the history of Hazelmere, but a lot of eminent people have lived there, great writers and so on. But two people I want to mention quickly. One, these are two men that are very special, local heroes, if you like. And one, I'll say quickly, was William Beveridge, who you probably know, was the author of the Beveridge Report, the blueprint for the welfare state, the National Health Service. There's another far-seeing man. I'm going to bring him in a bit later on because he's very important to this. But as I said, I've made this my home for 65 years. I brought up my family there. Now my grandchildren enjoy the beauty and pleasure of its magnificent surroundings. I'm not alone in my love for this piece of heaven. My own father, who was brought up in a very scenic part of Ontario and travelled the entire world, declared it to be the loveliest place on the planet. I remember that well. But long before his time, others had similar thoughts. The Victorian writer, Anne Gilchrist, Hazelmere seemed like paradise to her. She said in 1863, she wrote to a friend, "The scenery around here is of surpassing loveliness." And in her wake, many eminent writers, poets, playwrights, scientists, philosophers, and social reformers followed her example and sought solace and inspiration for the wild hills and the clean, fresh air of deepest Surrey. Among them was the novelist George Eliot, who wrote in 1871, "Life here is immensely enjoyable. Our country could hardly be surpassed in its particular kind of beauty. Perpetual undulation of heath and copse, and clear views of hurrying water, with here and there a grand pine wood, steep wood-clothed promontories, and gleaming pools." As for anyone who's ever walked intensely in this area, you'll know immediately she's referring to the glorious delights of Belle Vale and Chase Valley, where the River Wey springs out of Blackdown and hurries its way down to Sturt Meadow. It's without doubt a beautiful and beguiling area to live and work in, and it is deservedly designated as an area of outstanding natural beauty. Over the past 2 centuries, planners and developers have worked hard together to achieve the balance between essential housing and preserving the visual delights of their surroundings. In 2010, Hazlemere residents clearly stated their will regarding any development of Redcourt Estate, which of course is Scotland Park, in the Hazlemere design statement. It was a resounding no to development and a yes for preservation. The statement drawn up by local councillors, business and residents concluded, beautiful areas around us must be preserved and maintained, and where possible, enhanced. Redcourt Estate, privately owned, is a continuation of the beautiful Chase Valley and Valewood Park, owned by the National Trust. This green space needs to be preserved as an area of transition between the built-up area of Hazlemere and the National Park boundary. This should be taken into account when determining any new building development. The statement was adopted by the Town Council and Waverley Borough Council in 2012. I take that to have meant in perpetuity, or at least for a generation, not just for a few short years. And I have always believed that people matter more than anybody else. Now, if you lived there and walked as I have, its myriad of footpaths, stood alone and breathed in the alpine air, Gibbet Hill or Blackdown while taking these magnificent views, or enjoyed the quiet tranquility of the streams along Belle Vale, or looked down on the magnificence of the Devil's Punch Bowl, everything you see around you stems from mostly to the Herculean efforts of one man, our second hero, co-founder of the National Trust, Sir Robert Hunter. He made his home in Hazlemere and became chairman of the parish council. For his lifetime's achievements, he was destined to be buried in Westminster Abbey, but with characteristic modesty, he chose an unmarked pauper's grave in Hazlemere's St. Bartholomew's Church. He wanted his last resting place to be among his people. And the town he loved. A fine orator. There could be no one more qualified to have the last word on this subject, and I'm going to give it to him now. He knew a thing or two about planning and development, and in 1907 he delivered this speech. If we turn to natural scenery, we find that not even the more striking manifestations of nature are safe from the hand of man. In the exercise of power, in the furtherance of the subjection of nature to his rule, he is often the impatience and thoughtlessness of a child, and will ruthlessly destroy beauty of appearance and association. The beauty of hill and vale, wood and water excites in us not merely a delight in colour and form, but a subtle sense of the vastness and permanence of the physical world, of the weakness of man, of the late birth of the human race, and of the fleeting character of human life. Natural beauty, equally with historic association, stimulates the imagination and takes the beholder out of the petty cares and the small details of everyday existence. If the nation is vigilant to save what is interesting and beautiful in its lands and buildings, life will be better worth having for its citizens, not only of today, but of centuries to come. Robert Hunter devoted his life to preserving these things and protecting them from overdevelopment. He died more than 100 years ago, but his legacy lives on in our wonderful surroundings. In considering this appeal, I beg you to please consider the legacy he bestowed upon us.
Thank you very much indeed. Any questions?
So can I just ask again, are you a member of the Hazlemere South?
Absolutely not, no.
No questions?
Okay.
Okay.
If there's any, can I say I'm a member of no society?
Who would like to go? You're on your way. That looks like it. Thank you. Okay, if you can introduce yourself.
My name is Beavis Peters. I'm a resident of Scotland's Close, which neighbours the development. I'm going to comment on a very specific area close to some of our hearts here, with aspects to the privacy that will be affected, those of us neighbouring the development. The development is largely placed on top of a hill directly to the south of the houses on Scotland's Close. The houses of the development will be built on land that is around 3 metres higher than that on which our houses are built. This means that the ground floor windows of the new houses will look directly into the bedroom windows of the Scotland's Close houses. These houses were built in the late 60s with very large open windows, as was the fashion at the time. The first floor windows on the development will look straight into the bedroom windows of ours and directly overlook the gardens on Scotland's Close. The scrub which the developer planted on the side of the field adjacent to the housing offers no cover at all in winter and very little cover in the summer. And this is after around 8 years of growth that's been in place, as can be seen on photographs attached to the document. It's probably a decade or more away from offering any level of privacy screening. I would reckon there needs to be around 6 meters of mature growth to offer that. I believe that the development as it stands will result in a significant loss of privacy due to this extensive overlooking and should not be allowed to go ahead in its current design. I'd encourage an inspector to come and view the outlook from one of the Scotland Close houses.
Could you just talk, excuse me, could you just talk me through the photos there?
We've got 3 photographs here.
Yeah, yourself and 2 neighbours.
Yes, 3 neighbours. These are from the upstairs window looking south onto where the development would be. You can see the line of some of the hedging and the field on which the houses will be built.
And in your statements, sorry, I don't want to misquote you. Yeah, you talk about the scrub which the developer has planted on the side of the field.
Yes, there is a tract between 2 fences.
Right.
Where...
That I'll obviously pick up on site.
Yes,
that doesn't quite pick up on the photos, does it?
It's not so easy to see on the photos, no, but you can make it out. It will be very obvious when you go.
When I go on site,
yes.
Okay. Any questions, Mr. Marici?
Just my usual one. Are you a member of the
questions?
Hazel?
That's fine.
Are you a member of the Hazelmere South Residents
Yes.
Association? What about the Hazelmere Society?
No.
So, and can I just check these photographs? They were taken from the upstairs windows, first
Yes.
floor windows, yes. And they're obviously all taken in winter because there's no leaves on the trees. Is that correct?
They were taken recently, therefore winter, yes.
Thank you very much. Those are my questions. Thank you.
Thanks very much for your time. Oh.
Hello, sir. I shall have my email now because I've made some adjustments.
Yeah, if you can try and read your adjustments. Yeah, read the adjustments, but then try and. What am I trying to say? I'll start again.
I'll redo it and put it up properly.
Yes, that's
That's
right.
okay.
That's what I was trying to say. Okay, if you could introduce yourself.
Yeah, good afternoon. My name is Dawn Brown and I am a trustee of Hazelmere Society and a member of the HRSA. I'm both a mother and grandmother and have been a Hazelmere resident for over 20 years. In particular, I would like to mention the topography that seems to have come up in these discussions. The picture painted, if you look at the new development, it's all on Hazelmere itself, is very one-dimensional, and it's a bit misleading because the topography of Hazelmere, it's very hilly. So to reach the main town, you need to cross over the main Midhurst Road as to Shepherd's Hill. So it's not very easy to walk or cycle. I would also like it noted that I agree with all the residents that have spoken so far against this proposal. I chose to live in Hazelmere for its protected green spaces that I have been able to enjoy over the last 20 years. I regularly walk from home down the footpath down to Bell Lane regularly with my 2 grandchildren, and they have benefited greatly from the wonderful experiences they have had when encountering new wildlife, plants and trees in the changing seasons. You cannot put a price on happiness and well-being. It enables children to stay physically fit and healthy and have a positive attitude on life. I also believe that it's essential that people of all ages are able to walk in green countryside. So moving the historic footpath between 2 roads will remove the tranquility it currently delivers. This is even more important for young people and preserving their mental health. If the developer were able to build on this beautiful countryside, it would be catastrophic in every way, and the numerous benefits it provides will be lost for future generations. I sincerely hope that you will take this into consideration and reject this appeal due to there being no exceptional circumstances. Thank you for your time.
Thank you. You okay with questions? If
Yes,
anyone-
absolutely, yes.
No, no questions.
No?
Thank you very much indeed.
Okay.
Yes.
Apologies, I don't have a written,
It's
I
okay.
was trying to print it out before I
That's fine.
arrived,
I'll,
but my
I'll
printer
make,
wasn't
I'll make
working.
notes. That's
Thank
absolutely
you.
fine.
If I can.
If you could just introduce yourself and.
Yes.
Yeah.
Good afternoon. I'm Councillor Dr. Fazana Aslam. I sit on the Town Council, the Hazelmere Town Council. I should also say that I live on the Midhurst Road and I drive through that beautiful natural canopy of trees almost on a daily basis. I have a deep personal affection and attachment to the area, which falls within the subject matter of this current inquiry. But I'm here today speaking on behalf of Hazelmere Town Council to show its support to the residents and to confirm why it is that the Town Council voted unanimously to support the Rule 6 group in opposing this application. That decision reflects a strong cross-party consensus rooted in our collective commitment to protecting the environment, our town's rural character, and the long-term well-being of our community. The Town Council has made clear time and again through our neighbourhood plan, our environmental strategy and public statements that we are committed to fighting climate change and ecological degradation, to protecting habitats and species at risk, and to ensuring that development is sustainable, appropriate, and in keeping with the local character of Hazelmere. Supporting the Rule 6 group is therefore not simply a reaction to this specific development. It's a continuation of our strategic position and duties to the community we serve. These values are not just a reflection of councillors' opinions, they are principles set out in the Hazelmere Neighbourhood Plan, which was adopted by local referendum, reflecting the democratic expression of the town's priorities and the will of the community. I'd like to highlight two key policies. Policy H9, which states that development proposals must demonstrate a net gain in biodiversity and avoid damage to or loss of biodiversity assets. And Policy H4, which requires that development complement and enhance the character of the area. This development, in our view, does exactly the opposite. It would lead to unacceptable encroachment into open countryside, unacceptable and irreversible encroachment into open countryside, something that the neighbourhood plan seeks to prevent. The plan's vision is also clear and worth restating. Hazelmere will grow modestly in a way that is sensitive to its outstanding natural surroundings and heritage, and will remain a pleasant, vibrant, healthy and attractive place to live and work. The scale and location of this development undermines that vision and the values that we were elected to uphold. This development would lead to unacceptable harm and something that the neighbourhood plan seeks to prevent. In supporting the Rule 6 group, Hazelmere Town Council is standing by the principles our community endorsed in the neighbourhood plan. We urge the inspector to give serious consideration to this democratically adopted plan, to recognise the genuine and widespread local concern voiced by the community of Hazelmere, and to recognise the unanimity and clarity with which the Town Council has responded to this application, and to give due weight to the environmental, ecological and community impacts at the heart of this case. This is not simply about opposing one development. It's about standing by the environmental principles we've committed to as a council and as a community, and defending a long-term vision for Hazelmere, its landscape and its ecology. Thank you.
Thank you. Thank you very much.
I'd like to add one other thing,
Yeah, of course.
which is in relation, unfortunately, I wasn't at the beginning of the hearing, but I gather that representations have been made, or there's been some comment made about the Scouts being homeless. I am able to comment on that because I contacted Waverley at before the last hearing to ask about the status of the Hazelmere Scouts. And in an email from Caroline Wallace from the Waverley Borough Council, she assured me that they had been offered a lease. It was going to be a 15-year lease, and that they were waiting for the Scouts to sign.
I don't know whether the Scouts actually did. I don't know what the current status of it is, but I would urge you, I think it's misleading to state that they're going to be homeless. It simply is not my understanding of the situation.
I think, thank you. You're right. There were references made earlier on to the position of the Scouts. I think we've got somebody from the Scouts due to speak who may be able to clarify it, and also I'm sure the council can clarify it.
Thank you.
So between the two of you, perhaps we can clarify that
Great.
point.
Thank you.
Thanks for that. Any questions, Mr. Marici? You okay with questions?
Yes.
Yeah, I just wanted to check, when you spoke at the inquiry last time, you indicated you were not speaking on behalf of the town council, but in your personal capacity.
Yes.
This time, as I understand it, are you saying you are speaking in your capacity as town councillor?
Absolutely, yes.
And so the town council have passed some resolution that you're authorised to speak for them, is that right?
Yes, myself and whether we passed an exact resolution, I'm not sure, but we made it clear that we would be speaking, we would be here at the hearing representing Hazelmere. I represent Hazelmere South.
And are you a member of the Hazelmere South Residents
I'm not.
Association? What about the Hazelmere Society?
No.
And can I ask you this? We've discussed this previously, but at the last inquiry, the council indicated that it was imminently going to provide a lease to the Scouts. 14 months on, and we have evidence from the Scouts, it hasn't progressed one jot. So, I mean, are you saying to the inspector he can rely on the fact that you, 15, 16 months ago, asked the council whether they were going to grant a lease and they assured you they were? That's as far as you can take it.
That is as far as I can take it. I raise it simply to I guess raise this as an issue, that it's something that needs to be investigated more fully than simply accepting that the Scouts don't have a lease and are going to be homeless, because they made that argument last time when in fact it wasn't the case.
Well,
Waverley had assured me that they had been offered a lease.
Well, it was the case, but it doesn't really matter what the position was before. The position now is you're not able to offer anything in terms of evidence beyond an inquiry you made, 15 months ago?
Absolutely. I'm not
Okay.
trying to enter it as
Right.
evidence.
That's
I'm
fine.
trying to raise a point of concern that the inspector ought to be aware of.
Thank you. That's all.
Okay, thanks very much for your time. I wonder if it probably makes sense, if it's okay with you, could we hear from Mr. Buckler now for the Scout group? Is that okay? Well, can we discuss that once we're up here? Just whilst Mr. Buckler's coming, is the council going to be able, I obviously don't know what he's going to say, but does the council know what the position is on the list?
Yes, we do. Mr. Johnson will speak to it in evidence in due
Okay,
course,
we'll do
but
it.
I'll be asking some questions, I suspect.
Yeah. Right, do I have a written statement from you?
I don't have a statement.
Fine.
I'm quite happy to write down what I've written.
I'm happy to take notes, it's fine.
At the previous inquiry, I think there are several letters of support that we've submitted. There is a document which is a project brief and a funding statement for the viability of the Scout hut. There is also a document which contains answers to some questions that were raised at the last inquiry by members of the public. So I don't know if you've read all of those.
I have read some statements from the last inquiry related to the Scouts, but unless you tell me which ones they are specifically.
Okay, can I follow up with writing, and I'll let you know which ones I mean.
If you can simply identify what the documents are. Sorry, let me just make a note of that. I mean, by all means, in a second, say what you want to say, but as a separate matter, can you just identify the documents I ought to look at? So, floor is yours.
Yeah, okay. So my name is Paul Buckler. I'm a resident of Hazelmere. I've lived in Hazelmere for 19 years. Like 85% of the people that have made comments on this planning application, I live within half a mile of the site. I have been the chair of the Scout group since 2010, so 15 years. The Scout group has been in Hazelmere since 1909, when we were established. We've been on our current site, leasing it from various local councils since 1924. In 1984, we built our current building, and we have had a lease for the land since the early 80s, which has now lapsed. In 2015, we asked the council for a new lease. We then received a letter from the then leader of the council, reassuring us that a new lease was with the legal team and was about to be issued. One day after the local elections that year, we received a counter notice saying that we were in breach of tenancy. We then spent the next 4 years working with the council to find a suitable alternative and exploring all the options that were open in terms of an alternative site. In 2019, we'd exhausted all of the options that were available at that time, and we agreed with the council that we would negotiate a new lease. In 2021, I signed a new lease. We ran round, it was signed by another member of the committee, and we brought that, it was also signed by the Scouts Association Trust Corporation in London, and that was brought to Waverley Borough Council. In September of that year, we were informed that lease had been lost. So we then signed another lease, another copy of the lease. And in December that year, the leader of the council asked for a meeting with us, which we attended, and we were informed that the council had no intention of signing that lease. In 2022, we submitted a court claim in Guildford for a new lease. In 2023, a stay of that particular claim was agreed, and we've tried to negotiate a lease with the council. In March 2024, just around the time of the last inquiry, we tried to contact the council to move negotiations on, and we heard nothing. In May last year, we contacted the council and heard nothing. In August, we contacted the council and heard nothing. In September, we contacted the council and heard nothing. In November, we contacted the council and heard nothing. In February this year, we contacted the council and heard nothing, other than we are waiting for our client's instruction. That's it. In September last year, we were made aware. Oh, could I get some water? Yeah. Yeah, of course. You get a bit dry, don't you? Yeah, sorry. It's okay. I don't normally do this. No, it's fine. Thank you. Cheers. So in September last year, we heard that Hazelmere Town Council had organised a working party to discuss the option of moving the youth campus from its current location to the car park on Waydown Road. We tried to make contact with Hazelmere Town Council in September last year, and we've heard nothing. We then tried again in November last year and heard nothing. Since all of the challenges with the lease of where we are started, we've had to reduce the size of the group because of the uncertainty of where we were going to be. And we didn't feel that it was correct to bring children into the group if there was going to be a challenge in terms of where we meet. The existing site, I believe, is in the local plan. The land adjacent to ours is in the local plan for housing. So there is obviously, with the lack of progress with the council and our landlord, there's obviously a challenge in terms of housing scouts in Hazelmere. Scotland Park, I think it was mentioned earlier, is a generational opportunity for the scouting movement in Hazelmere. It would place us back at the edge of the town, which is where we were back in 1924. It's within walking distance of the South Downs. It would provide a campsite. It would provide an efficient building to operate from. It won't require public funds in terms of establishing a building and providing land. We plan to run it as a community hall. We plan to offer it to schools so that they can run their D&V expeditions from the campsite. And we also plan to offer it to for use by the wider community for other activities that are compatible with the site. And we also plan to offer it to the wider scouting movement. So in summary, for us, we are a group of volunteers who are the current custodians of a scout group that's been in the town for well over 115 years. And we're just looking for a home, and that's what Scotland Park is offering.
Thank you very much. Can I just pick up on one point? My typing didn't quite keep up at one point. You'd been on your current site since when? It was the date or the number of years?
1924, so 101 years.
24, okay. Thank you very much. Any questions from the council?
Yes, thank you, sir.
You okay with questions?
Yeah, sure. If I can't answer, I'll follow up with something in writing.
Yeah, good afternoon, Mr. Buckler. I'm representing the council at this inquiry. Now, just so I understand the position, I've read your letter to the inspector dated February 2025, which the appellants have appended to their planning evidence. So I understand that position. And in that letter, you talk about your history at the site, and you indicate you faced ongoing uncertainty with an unresolved lease situation, is the way you put it. Now, I've spoken to officers, in particular Caroline Wallace, who's the strategic asset manager for the council. Do you know her?
I do.
Yeah. My instructions, which are very different from what you've been saying, so perhaps we'll have to get to the bottom of this for the inspector, but my instructions are that the council property department has been keen and has indeed been offering you a new lease for a number of months, and just hasn't heard anything back from you.
So I will provide the emails as a record.
Okay. Well, that's so. Look, I'm not suggesting anything beyond, but I want to put that to you. Well, obviously, we can look into it if it's going to assist the inspector more. But those are my instructions, that you have been offered a continuing another 15-year term at a peppercorn rent. Is that right?
We are in negotiation. However, since last March, the last inquiry where the leader of the council made a statement of, we have every intention of signing a lease. We have had no comeback in terms of our attempts to negotiate. All we have had from the solicitors is we are waiting for our client's instruction, and I'm quite happy to provide that communication.
You say then, you said a moment ago, I think we're in negotiations, the way you put it. Yes. And
we agreed a stay of the court claim, and we are trying to agree a lease.
Yes, exactly.
Which we did do before, which I signed. And I believe there is a copy in this building.
Okay, we'll come back to that. So you're in negotiations, you're trying to negotiate, and ideally, from your point of view, sign a lease.
We would like to have surety of what's happening with the scouts in terms of the location.
You would like to negotiate and, if at all possible, sign a lease, is my question to you.
We would like to sign a lease, as we have been trying to sign a lease for 15 years.
Yes. And if it's the position, and we can, if need be, we can assist the inspector by calling evidence. My instructions are that the council has been trying to offer you one, but in any event, council's position is that it's quite prepared to offer you a lease for another 15 years on a peppercorn rent. If that's the position, you may take issue with that, but you would be content to accept that offer, would you?
If we have an offer of a lease that's acceptable to the committee, yes, we would sign it, as we signed a previous lease in 2021.
Well, if it were a lease on much the same terms that you have had in the past, you'd be content with that, would you?
Yeah, we would be content with something that has terms and conditions that are acceptable.
And then, so again, we'll get to the bottom of who's right on whether you've been offered or not. I don't want to trouble you anymore with that at the moment. But assuming that's the position and you're offered a lease on those terms, that would be your preference to remain where you've been since 1924?
So in 1924, the Scouts were at the edge of Hazelmere. Scotland Park is obviously a superior offering for the Scouts because it has a campsite, because it has a brand new building. If that is not on the table, then we're, we would like a lease, because for the simple reason Scotland Park won't be delivered, even if it's approved, for another 5 or 6 years.
Yes, at least. Look, I understand that. It's my bad phraseology. Assuming the council would, or as I'm instructed, trying to and indeed prepared to offer you a 15-year term peppercorn rent on the site that you are on now, that would be something you would wish to take up.
We would take that up if that's the only option.
And if, well, okay, and assuming you took that up, that would meet the need you have for a Scout facility. It may not be the prettiest Scout facility, it may not be in the natural landscape with a nice woodland setting, but it would meet your need for a Scout facility, wouldn't it?
It currently meets our needs, and that's the reason why we've fought so hard to protect our position.
All right, that's fair. And I'm also told, and again, we can bottom this out, that to the extent the site you're on may be redeveloped in the future, it's also been indicated to you that the council will be prepared to relocate you to a new unit on that site. Is that right?
There's been no concrete plans offered.
Right. Well, is it right that you've been made aware of that position?
If my memory serves me correctly, in 2017, there was, I believe, there was an outline for a building at the youth campus, but that did not materialise. I think that's 8 years ago.
Yeah, great. So thank you. I hope, just for my submissions, and I don't want to be unfair to you later on, but assuming you enter into a lease with the council on the site you're on now, in the terms we've discussed, there wouldn't be any necessity. I understand you'd prefer to have the site in the national landscape in the woodland. I understand that point. But in terms of pure necessity, there wouldn't be a necessity for you to have that site if you had a renewed lease on the current site.
Yes, it's in the council's gift to give us a lease, because, as I said, there's a copy in this building where I've actually signed a lease.
Yeah, that's very fair. Thank you, sir. Thank you for your time.
Thanks very much. I don't believe that there's a conspiracy or coincidence, but to me, the challenge we've had of finding somewhere to locate and to operate from for the long term has been a real challenge. And if it was easy for the council to provide something for us and to deal with the housing demand, I think it would have happened.
Anything on that?
So can I help you on the documents by identifying the previous representations that the Scouts have put in that we've got?
Thank you.
So, sir, I think, as Mr. Cosgrove rightly said, there is the most recent, the February 25 letter is in Mr. Collins' proof for this inquiry at Appendix 4. And that's the one that's got, so that's a February 25 letter, and it's also got the project brief and funding statement, which was referred to. And so there are then 4 other references that I found in the core documents. So CD 3.29 and CD 3.30 are 2 of the earlier representations from the Scouts. And then so there is also at ID 5.9, so that's the inquiry documents from the last inquiry. There's a chronology that was submitted by the Scouts as to their history on the site. And then so finally, NID 2.4 is another representation from the Scouts in the context of this inquiry. So those are the ones I've found. There's 4 of them, for 5 in total, actually. So that's what I've found. I'm assuming that's everything, but if it's not, you can probably let us know, but we can check.
Yeah, the only thing not included in the lease is the lack of progress since the last inquiry.
Okay. Right, I've got those document references. So let me be clear in my mind that there is obviously no lease at the moment on the current site.
Correct.
That is agreed. And
Well, I suspect, I don't know, because I suspect it's rolling over. Depends on what the provision of the lease
okay.
are. They normally
Yeah.
roll it. I don't know, but I suspect there's a default position.
there
I
isn't at the moment.
The lease is
There
is
isn't hang on.
the existing.
There isn't at the moment a new lease, let's put it that way. And what I'm hearing is the 2 parties saying, well, we've been trying to contact you, we've been trying to contact you, da-da-da-da-da. Simple question to all parties, do I need to get to the bottom of that? The Scouts are there at the moment. They don't have a new lease. They may be rolling over. I know what the proposal is. From the point of view of the 3 parties and the Scouts, do I need to get to the bottom of that? And frankly, am I going to be able to get to the bottom of that? Where does it take me?
Well, so I think the issue it goes to is about whether there is a need for a Scout facility as part of our proposal. So I think the only point it goes to really is the weight that you give to that. I may be wrong, but I mean, I think on any view, the position is that the facility that's being offered on site is superior to the existing and would be preferred because it's a better facility. But the question is need. Is there a need for it? That as I understand it, could be that's the only dispute I think there could be between us.
So, I mean, tell me if I'm wrong. What we're saying is that the appeal scheme proposal for the Scout facility is better than what you have at the moment. So the only question is, given that your position on your current site, shall we say, is uncertain, yes, it goes to need, doesn't it?
I wouldn't assume it is uncertain. So that's
well.
But you've heard my position.
Well, it's uncertain in that there's no new lease.
Well, well, I don't want to second guess. Well, our position is the lease has been offered. If no response is made, you may say that's uncertainty. It was only uncertainty because of a given particular position the party's taken.
Yeah.
So can I just answer your question? I don't disagree, Mr. Marici. It's put part of the scheme, it's part of the development, it's also put forward as a benefit, which invites us to give way. So the issue, if one breaks it down as a Regulation 122 issue from our perspective, yes, it's part of the development, but is it necessary? If it's necessary and meets the other tests, you may quite properly give it more weight. On the other hand, if you come to the view that it is not necessary for a number of reasons, either because it's possible for them to remain where they are, which may be an issue, or there's no lease and it might be superior but not necessary. Certainly in those we will be submitting that you're going to give it limited or no weight.
Yeah.
No one's disputing the council would be very nice to have a Scout facility, the lovely environment, but from our point of view, it really goes to the issue of necessity and what weight you can give it as a benefit. So I've asked my questions. Obviously, I'll take instructions in light of what I've heard again. I had taken instructions to put those points to the gentleman, and I'll get Mr. Johnson to give you the evidence from the council what we understand our position to be.
Yeah. Okay.
I mean, I totally understand Mr. Buckley's position that he wants to see documents. There may come a point. I just want to be fair. I'm not going to. If we get to a point where you think it's necessary to see whether there've been emails sent discussing or not, we'll take a view and make sure Mr. Buckley, I think the appellant sees them. But I'm going to try and deal with it on instructions.
I would rather not get to that point, frankly.
Yeah.
But yeah, okay. See where we get to on that. Thank you very much indeed for your time. Okay, let's take a break for a slightly late lunch. It's 1:45 now. Shall we resume at 2:30 then, please?
Yes, is it worth, I don't know how many people we've got left to speak, just in terms of where we are on the timetable. You've got a better list than me, probably.
I've got one, well, let's see. I have got Mr. Strachan. One gentleman approached me and said he couldn't be here till 2:30. That might have been him. Yes. I've got Councillor Terry Weldon. Oh, indeed, sorry. Nikki Barton. Oh, sorry. That's all I've got. So, so three people at 2:30. You're going to investigate, if you haven't already, the question of the PowerPoint.
Yes.
Okay.
So do you want me to distribute now the presentation in hard copy?
Let's have it in hard copy and yeah, okay, right, 2:30 then, please. Paper, ouch. Okay, thanks. Put that over there.